'Cause there ain't no doubt I love this land. God bless.
Authenticated U.S. Government Information, GPO, page 1 of 1018. "119th Congress, First Session, H.R. 1 and Act, to provide for reconciliation pursuant to Title II of H. Con. Res. 14. Be it enacted by the Senate and House of Representatives of the United States of America and Congress assembled. This act may be cited as the One Big Beautiful Bill Act." Section 2, Table of Contents. The table of contents of this act is as follows. Section 1, short title. Section 2, Table of Contents. Title 1, Committee on Agriculture. Subtitle A, Nutrition. Section 10001, Thrifty Food Plan. Section 10002, Able-bodied adults without dependents, work requirements. Section 10003, Able-bodied adults without dependents waivers. Section 10004, Availability of standard utility allowances based on receipt of energy assistance. Section 10005, Restrictions on internet expenses. Section 10006, Matching funds requirements. Section 10007, Administrative cost sharing. Section 10008, General work requirement age. Section 10009, National Accuracy Clearinghouse. Section 10010, Quality Control Zero Tolerance. Section 10011, National Education and Obesity Prevention Grant Program Repealer. Section 10012, Alien SNAP Eligibility. Section 10013, Emergency Food Assistance. Subtitle B, Investment in Rural America. Section 10101, Safety Net. Section 10102, Conservation. Section 10103, Supplemental Agricultural Trade Promotion Program. Section 10104, Research. Section 10105, Secure Rural Schools, Forestry. Section 10106, Energy. Section 10107, Horticulture. Section 10108, Miscellaneous. Title II, Committee on Armed Services. Section 20001, Enhancement of Department of Defense Resources for improving the quality of life for military personnel. Section 20002, Enhancement of Department of Defense Resources for shipbuilding. Section 20003, Enhancement of Department of Defense Resources for integrated air and missile defense. Section 20004, Enhancement of Department of Defense Resources for munitions and defense supply resiliency. Section 20005, Enhancement of Department of Defense Resources for sealing low-cost weapons into production. Section 20006, Enhancement of Department of Defense Resources for improving the efficiency and cybersecurity of the Department of Defense. Section 20007, Enhancement of Department of Defense Resources for air superiority. Section 20008, Enhancement of Resources for Nuclear Forces. Section 20009, Enhancement of Department of Defense Resources to improve capabilities of United States Indo-Pacific Command. Section 20010, Enhancement of Department of Defense Resources for improving the readiness of the armed forces. Section 20011, Improving Department of Defense border support and counter-drug missions. Section 20012, Department of Defense oversight. Section 20013, Military construction projects authorized. Section 20014, Plan required. Section 20015, Limitation on availability of funds. Title 3, Committee on Education and Workforce. Subtitle A, Student Eligibility. Section 30001, Student Eligibility. Section 30002, Amount of Need, Cost of Attendance, Median Cost of College. Subtitle B, Loan Limits. Section 30011, Loan Limits. Subtitle C, Loan Repayment. Section 30021, Loan Repayment. Section 30022, Deferment Forbearance. Section 30023, Loan Rehabilitation. Section 30024, Public Service Loan Forgiveness. Section 30025, Student Loan Servicing. Subtitle D, Pell Grants. Section 30031, Eligibility. Section 30032, Workforce Pell Grants. Section 30033, Pell Shortfall. Subtitle E, Accountability. Section 30041, Agreements with Institutions. Section 30042, Campus-Based Aid Programs. Subtitle F, Regulatory Relief. Section 30051, Regulatory Relief. Subtitle G, Limitation on Authority. Section 30061, Limitation on Authority of the Secretary to propose or issue regulations and executive actions. Title 4, Energy and Commerce. Subtitle A, Energy. Section 41001, Rescissions relating to certain Inflation Reduction Act programs. Section 41002, Natural gas exports and imports. Section 41003, Funding for Department of Energy Loan Guarantee Expenses. Section 41004, Expedited Permitting. Section 41005, De-risking Compensation Program. Section 41006, Strategic Petroleum Reserve. Subtitle B, Environment. Part 1, Repeals and Rescissions. Section 42101, Repeal and Rescission relating to clean heavy-duty vehicles. Section 42102, Repeal and Rescission relating to grants to reduce air pollution at ports. Section 42103, Repeal and Rescission relating to Greenhouse Gas Reduction Fund. Section 42104, Repeal and Rescission relating to diesel emissions reductions. Section 42105, Repeal and Rescission relating to funding to address air pollution. Section 42106, Repeal and Rescission relating to funding to address air pollution at schools. Section 42107, Repeal and Rescission relating to low emissions electricity program. Section 42108, Repeal and Rescission relating to funding for Section 211 of the Clean Air Act. Section 42109, Repeal and Rescission relating to funding for implementation of the American Innovation and Manufacturing Act. Section 42110, Repeal and Rescission relating to funding for enforcement, technology, and public information. Section 42111, Repeal and Rescission relating to greenhouse gas corporate reporting. Section 42112, Repeal and Rescission relating to environmental product declaration assistance. Section 42113, Repeal and funding for methane emissions and waste reduction incentive program for petroleum and natural gas systems. Section 42114, Repeal and Rescission relating to greenhouse gas air pollution plans and implementation grants. Section 42115, Repeal and Rescission relating to Environmental Protection Agency efficient, accurate, and timely reviews. Section 42116, Repeal and Rescission relating to low embodied carbon labeling for construction materials. Section 42117, repeal and decision relating to environmental and climate justice block grants. Part 2, repeal of EPA rules relating to greenhouse gas and multi-pollutant emissions standards. Section 42201, repeal of EPA rules relating to greenhouse gas and multi-pollutant emissions standards. Part 3, repeal of NHTSA rules relating to CAFE standards. Section 42301, repeal of NHTSA rules relating to CAFE standards. Subtitle C, communications. Part 1, spectrum auctions. Section 43101, identification and auction of spectrum. Part 2, artificial intelligence and information technology modernization. Page 5 of 1018. Section 43201, artificial intelligence and information technology modernization initiative. Subtitle D, help. Part 1, Medicaid. Subpart A, reducing fraud and improving enrollment processes. Section 44101, moratorium or implementation of rule relating to eligibility and enrollment in Medicare savings programs. Section 44102, moratorium on implementation of rule relating to eligibility and enrollment for Medicaid, CHIP, and the Basic Health Program. Section 44103, ensuring appropriate address verification under the Medicaid and CHIP programs. Section 44104, modifying certain state requirements for enduring deceased individuals do not remain enrolled. Section 44105, Medicaid provider screening requirements. Section 44106, additional Medicaid provider screening requirements. Section 44107, removing good faith waiver for payment reduction related to certain erroneous excess payments under Medicaid. Section 44108, increasing frequency of eligibility redeterminations for certain individuals. Section 44109, revising home equity limit for determining eligibility for long-term care services under the Medicaid program. Section 44110, prohibiting federal financial participation under Medicaid and CHIP for individuals without verified citizenship, nationality, or satisfactory immigration status. Section 44111, reducing expansion FMAP for certain states providing payments for health care furnished to certain individuals. Subpart B, preventing wasteful spending. Section 44121, moratorium on implementation of rule relating to staffing standards for long-term care facilities under the Medicare and Medicaid programs. Section 44122, modifying retroactive coverage under the Medicaid and CHIP programs. Section 44123, ensuring accurate payments to pharmacies under Medicaid. Section 44124, preventing the use of abusive spread pricing in Medicaid. Section 44125, prohibiting federal Medicaid and CHIP funding for gender transition procedures. Section 44126, federal payments to prohibited entities. Subpart C, stopping abusive financing practices. Section 44131, sunsetting eligibility for increased FMAP for new expansion states. Section 44132, moratorium on new or increased provider taxes. Section 44133, revising payments for certain state-directed payments. Section 44134, requirements regarding waiver of uniform tax requirements for Medicaid provider tax. Section 44135, requiring budget neutrality for Medicaid demonstration projects under Section 1115. Subpart D, increasing personal accountability. Page 6 of 1018. Section 44141, requirement for states to establish Medicaid community engagement requirements for certain individuals. Section 44142, modifying cost sharing requirements for certain expansion individuals under the Medicaid program. Part 2, Affordable Care Act. Section 44201, addressing waste, fraud, and abuse in the ACA exchanges. Section 44202, funding cost sharing reduction payments. Part 3, improving Americans' access to care. Section 44301, expanding and clarifying the exclusion for orphan drugs under the Drug Price Negotiation Program. Section 44302, streamlined enrollment process for eligible out-of-state providers under Medicaid and CHIP. Section 44303, delaying DSH reductions. Section 44304, modifying update to the conversion factor under the physician fee schedule under the Medicare program. Section 44305, modernizing and ensuring PBM accountability. Title V, Committee on Financial Services. Section 50001, Green and Resilient Retrofit Program for Multifamily Family Housing. Section 50002, Public Company Accounting Oversight Board. Section 50003, Bureau of Consumer Financial Protection. Section 50004, Consumer Financial Civil Penalty Fund. Section 50005, Financial Research Fund. Title VI, Committee on Homeland Security. Section 60001, Border Barrier System Construction, Invasive Species, and Border Security Facilities Improvement. Section 60002, U.S. Customs and Border Protection Personnel and Fleet Vehicles. Section 60003, U.S. Customs and Border Protection Technology, Vetting Activities, and Other Efforts to Enhance Border Security. Section 60004, State Border Security Reimbursement. Section 60005, State and Local Law Enforcement Presidential Residence Protection. Section 60006, State Homeland Security Grant Program. Title VII, Committee on the Judiciary. Subtitle A, Immigration Matters. Part 1, Immigration Fees. Section 70001, Applicability of the Immigration Laws. Section 70002, Asylum Fee. Section 70003, Employment Authorization Document Fees. Section 70004, Parole Fee. Section 70005, Special Immigrant Juvenile Fee. Section 70006, Temporary Protected Status Fee. Section 70007, Unaccompanied Alien Child Sponsor Fee. Section 70008, Visa Integrity Fee. Section 70009, Form I-94 Fee. Section 70010, Yearly Asylum Fee. Section 70011, Fee for continuances granted in immigration court proceedings. Page 7. Section 70012, Fee relating to renewal and extension of employment authorization for parolees. Section 70013, Fee related to termination, renewal, and extension of employment authorization for asylum applicants. Section 70014, Fee relating to renewal and extension of employment authorization for aliens granted temporary protected status. Section 70015, Diversity Immigrant Visa Fees. Section 70016, EOIR Fees. Section 70017, ESTA Fee. Section 70018, Immigration User Fees. Section 70019, EVUS Fee. Section 70020, Fee for sponsor of unaccompanied alien child who fails to appear in immigration court. Section 70021, Fee for aliens ordered removed in absentia. Section 70022, Customs and Border Protection Inadmissible Alien Apprehension Fee. Section 70023, Amendment to Authority to Apply for Asylum. Part 2, Use of Funds. Section 70100, Executive Office for Immigration Review. Section 70101, adult alien detention capacity and family residential centers. Section 70102, retention and signing bonuses for U.S. immigration and customs enforcement personnel. Section 70103, hiring of additional U.S. immigration and customs enforcement personnel. Section 70104, U.S. immigration and customs enforcement hiring capability. Section 70105, transportation and removal operations. Section 70106, information technology investments. Section 70107, facilities upgrades. Section 70108, fleet modernization. Section 70109, promoting family unity. Section 70110, funding Section 287G of the Immigration and Nationality Act. Section 70111, compensation for incarceration of criminal aliens. Section 70112, Office of the Principal Legal Advisor. Section 70113, return of aliens arriving from contiguous territory. Section 70114, state and local participation in homeland security efforts. Section 70115, unaccompanied alien children capacity. Section 70116, Department of Homeland Security checks for unaccompanied alien children. Section 70117, Department of Health and Human Services checks for unaccompanied alien children. Section 70118, information about sponsors and adult residents of sponsor households. Section 70106, information technology investments. Section 70117, Department of Health and Human Services checks for unaccompanied alien children. Section 70118, information about sponsors and adult residents of sponsor household. Section 70119, repatriation of unaccompanied alien children. Section 70120, United States Secret Service. Section 70121, combating drug trafficking and illegal drug use. Section 70122, investigating and prosecuting immigration-related matters. Section 70123, expedited removal for criminal aliens. Section 70124, removal of certain criminal aliens without further hearing. Subtitle B, regulatory matters. Section 70200, review of agency rulemaking. Subtitle C, other matters. Page 8. Section 70300, limitation on donations made pursuant to settlement agreements to which the United States is a party. Section 70301, solicitation of orders defined. Section 70302, restriction on enforcement. Title 8, Committee on Natural Resources. Subtitle A, Energy and Mineral Resources. Part 1, Oil and Gas. Sections 80101, onshore oil and gas lease sales. Section 80102, non-competitive leasing. Section 80103, permit fees. Section 80104, permitting fee for non-federal land. Section 80105, reinstate reasonable royalty rates. Part 2, geothermal. Section 80111, geothermal leasing. Section 80112, geothermal royalties. Part 3, Alaska. Section 80121, coastal plain oil and gas leasing. Part 4, coal. Section 80141, coal leasing. Section 80142, future coal leasing. Section 80143, coal royalty. Section 80144, authorization to mine federal minerals. Part 5, NEPA. Section 80151, project sponsor opt-in fees for environmental reviews. Section 80152, rescission relating to environmental and climate data collection. Part 6, miscellaneous. Section 80161, protest fees. Part 7, offshore oil and gas leasing. Section 80171, mandatory offshore oil and gas lease sales. Section 80172, offshore commingling. Section 80173, limitations on amount of distributed qualified outer continental shelf revenues. Part 8, renewable energy. Section 80181, renewable energy fees on federal lands. Section 80182, renewable energy revenue sharing. Subtitle B, water, wildlife, and fisheries. Section 80201, rescission of funds for investing in coastal communities and climate resilience. Section 80202, rescission of funds for facilities of national oceanic and atmospheric administration and national marine sanctuaries. Page 9, Section 80203, surface water storage enhancement. Section 80204, water conveyance enhancement. Subtitle C, federal lands. Section 80301, rescission of forest service funds. Section 80302, rescission of National Park Service and Bureau of Land Management funds. Section 80303, rescission of Bureau of Land Management and National Park Service funds. Section 80304, rescission of National Park Service funds. Section 80305, celebrating America's 250th anniversary. Section 80306, long-term contracts for the Forest Service. Section 80307, long-term contracts for the Bureau of Land Management. Section 80308, timber protection for the Forest Service. Section 80309, timber protection for the Bureau of Land Management. Title 9, Committee on Oversight and Government Reform. Section 90001, elimination of the FERS annuity supplement for certain employees. Section 90002, election for at-will employment and lower FERS contributions for new federal civil service hires. Section 90003, filing fee for Merit Systems Protection Board claims and appeals. Section 90004, FEHB protection. Title 10, Committee on Transportation and Infrastructure. Section 100001, Coast Guard assets necessary to secure the maritime border and interdict migrants and drugs. Section 100002, vessels tonnage duties. Section 100003, registration fee on motor vehicles. Section 100004, deposit of registration fee on motor vehicles. Section 100005, motor carrier data. Section 100006, IRA rescissions. Section 100007, air traffic control staffing and modernization. Section 100008, John F. Kennedy Center for the Performing Arts. Title 11, Committee on Ways and Means, the One Big Beautiful Bill. Section 11000, references to the Internal Revenue Code of 1986, etc. Subtitle A, Make American Families and Workers Thrive Again. Part 1, permanently preventing tax hikes on American families and workers. Section 110001, extension of modification of rates. Section 110002, extension of increased standard deduction and temporary enhancement. Section 11003, termination of deduction for personal exemptions. Section 110004, extension of increased child tax credit and temporary enhancement. Section 11005, extension of deduction for qualified business income and permanent enhancement. Page 10, Section 11006, extension of increased estate and gift tax exemption amounts and permanent enhancement. Section 11007, extension of increased alternative minimum tax exemption and phase out thresholds. Section 11008, extension of limitation on deduction for qualified residence interest. Section 11009, extension of limitation on casualty loss deduction. Section 11010, termination of miscellaneous itemized deduction. Section 110011, limitation on tax benefit of itemized deductions. Section 110012, termination of qualified bicycle commuting reimbursement exclusion. Section 110013, extension of limitation on exclusion and deduction for moving expenses. Section 110014, extension of limitation on wagering losses. Section 110015, extension of increased limitation on contributions to ABLE accounts and permanent enhancement. Section 110016, extension of savers credit allowed for ABLE contributions. Section 110017, extension of rollovers from qualified tuition programs to ABLE accounts permitted. Section 110018, extension of treatment of certain individuals performing services in the Sinai Peninsula and enhancement to include additional areas. Section 110019, extension of exclusion from gross income of student loans discharged on account of death and disability. Part 2, additional tax relief for American families and workers. Section 110101, no tax on tips. Section 110102, no tax on overtime. No tax on overtime. Section 110103, enhanced deduction for seniors. Section 110104, no tax on car loan interest. Section 110105, enhancement of employer-provided child care credit. Section 110106, extension and enhancement of paid family and medical leave credit. Section 110107, enhancement of adoption credit. Section 110108, recognizing Indian tribal governments for purposes of determining whether a child has special needs for purposes of the adoption credit. Section 110109, scholarship granting organizations. Section 110110, additional elementary, secondary, and homeschool expenses treated as qualified higher education expenses for purposes of 529 accounts. Section 110111, certain post-secondary credentialing expenses treated as qualified higher education expenses for purposes of 529 accounts. Section 110112, reinstatement of partial deduction for charitable contributions of individuals who do not elect to itemize. Section 110113, exclusion for certain employer payments of student loans under educational assistance programs made permanent and adjusted for inflation. Section 110114, extension of rules for treatment of certain disaster-related personal casualty losses. Section 110115, Trump accounts. Section 110116, Trump accounts contribution pilot program. Part 3, investing in health of American families and workers. Page 11. Section 110201, treatment of health reimbursement arrangements integrated with individual market coverage. Section 110202, participants in CHOICE arrangement eligible for purchase of exchange insurance under cafeteria plan. Section 110203, employer credit for choice arrangement. Section 110204, individuals entitled to Part A of Medicare by reason of age allowed to contribute to health savings accounts. Section 110205, treatment of direct primary care service arrangements. Section 11206, allowance of bronze and catastrophic plans in connection with health savings accounts. Section 110207, on-site employee clinics. Section 110208, certain amounts paid for physical activity, fitness, and exercise treated as amounts paid for medical care. Section 110209, allow both spouses to make catch-up contributions to the same health savings account. Section 110210, FSA and HRA terminations or conversions to find HSAs. Section 110211, special rule for certain medical expenses incurred of health savings account. Section 110212, contributions permitted if spouse has health flexible spending arrangement. Section 110213, increase in health savings account contribution limitation for certain individuals. Section 110214, regulations. Subtitle B, make rural America and Main Street grow again. Part 1, Extension of Tax Cuts and Jobs Act reforms for rural America and Main Street. Section 111001, Extension of Special Depreciation Allowance for Certain Property. Section 111002, Deduction of Domestic Research and Experimental Expenditures. Section 111003, Modified Calculation of Adjusted Taxable Income for Purposes of Business Interest Deduction. Section 111004, Extension of Deduction for Foreign Derived Intangible Income and Global Intangible Low Taxed Income. Section 111005, Extension of Base Erosion Minimum Tax Amount. Section 111006, Exception to Denial of Deduction for Business Meals. Part 2, Additional Tax Relief for Rural America and Main Street. Section 111101, Special Depreciation Allowance for Qualified Production Property. Section 111102, Renewal and Enhancement of Opportunity Zones. Section 111103, Increased dollar limitations for expensing of certain depreciable business assets. Section 111104, Repeal of Revision to De Minimis Rules for Third-Party Network Transactions. Section 111105, Increase in Threshold for Requiring Information Reporting with Respect to Certain Payees. Section 111106, Exclusion of Interest on Loans Secured by Rural or Agricultural Real Property. Section 111107, Treatment of Certain Qualified Sound Recording Productions. Section 111108, Modifications to Low-Income Housing Credit. Section 111109, Increased Gross Receipts Threshold for Small Manufacturing Businesses. Page 12 of 1018. Section 111110, Global Intangible Low Tax Income determined without regard to certain income derived from services performed in the Virgin Islands. Section 111111, Extension and Modification of Clean Fuel Production Credit. Section 111112, Restoration of Taxable REIT Subsidiary Asset Test. Part 3, Investing in the Help of Rural America and Main Street. Section 111201, explaining the definition of rural emergency hospital under the Medicare program. Subtitle C, Make America Win Again. Part 1, Working Families Over Elites. Termination of previously owned clean vehicle credit. Section 112002, termination of clean vehicle credit. Section 112003, termination of qualified commercial clean vehicles credit. Section 112004, termination of alternative fuel vehicle refueling property credit. Section 112005, termination of energy efficient home improvement credit. Section 112006, termination of residential clean energy credit. Section 112007, termination of new energy efficient home credit. Section 112008, restrictions on clean electricity production credit. Section 112009, restrictions on clean electricity investment credit. Section 112010, repeal of transferability of clean fuel production credit. Section 112011, restrictions on carbon oxide sequestration credit. Section 112012, restrictions on zero emission nuclear power production credit. Section 112013, termination of clean hydrogen production credit. Section 112014, phase out and restrictions on advanced manufacturing production credit. Section 112015, phase out of credit for certain energy properties. Section 112016, income from hydrogen storage, carbon capture added to qualifying income of certain publicly traded partnerships treated as corporations. Section 112017, limitation on amortization of certain sports franchisees. Section 112018, limitation on individual deductions for certain state and local taxes, etc. Section 112019, excessive employee remuneration from control group members and allocation of deduction. Section 112020, expanding application of tax on excess compensation within tax exempt organizations. Section 112022, increase in rate of tax on net investment income of certain private foundations. Section 112023, certain purchases of employee-owned stock disregarded for purposes of foundation tax on excess business holdings. Section 112024, unrelated business taxable income increased by amount of certain fringe benefit expenses for which deduction is disallowed. Section 112025, exclusion of research income limited to publicly available research. Section 112026, limitation on excess business losses of non-corporate taxpayers. Section 112027, 1% floor on deduction of charitable contributions made by corporations. Section 112028, enforcement of remedies against unfair foreign taxes. Page 13 of 1118. Page 13 of 1018. Section 112029, modification of treatment of silencers. Section 112030, modification to de minimis entry privilege for commercial shipments. Section 112031, limitation on drawback of taxes paid with respect to substituted merchandise. Section 112032, treatment of payments from partnerships to partners for property or services. Part 2, removing taxpayer benefits for illegal immigrants. Section 112101, permitting premium tax credit only for certain individuals. Section 112102, disallowing premium tax credit during periods of Medicaid ineligibility due to alien status. Section 112103, limiting Medicare coverage of certain individuals. Section 112104, excess tax on remittance transfers. Section 112105, Social Security number requirement for American Opportunity and Lifetime Learning Credits. Part 3, preventing fraud, waste, and abuse. Section 112201, requiring exchange verification of eligibility for health plan. Section 112202, disallowing premium tax credit in case of certain coverage enrolled in during special enrollment period. Section 112203, eliminating limitation on recapture of advance payments of premium tax credit. Section 112204, implementing artificial intelligence tools for purposes of reducing and recouping improper payments under Medicare. Section 112205, earned income tax credit reforms. Section 112206, tax force on the termination of direct file. Section 112207, increase in penalties for unauthorized disclosure of taxpayer information. Section 112208, restriction on regulation of contingency fees with respect to tax returns, etc. Subtitle D, increase in debt limit. Section 113001, modification of limitation on the public debt. Title 1, Committee on Agriculture. Subtitle A, Nutrition. This is the beginning of the big, beautiful bill. Section 10001, Thrifty Food Plan. Section 3U of the Food and Nutrition Act of 2008, 7 U.S.C. 2012U, is amended to read as follows. UI, Thrifty Food Plan means the diet required to feed a family of 4 persons consisting of a man and a woman 20 through 50, a child 6 through 8, and a child 9 through 11 years of age, based on relevant market baskets that shall only be changed pursuant to paragraph 3. The cost of such diet shall be the basis for uniform allotments for all households, regardless of their actual composition. The secretary shall only adjust the cost of the diet as specified in paragraphs 2 and 4. 2. Household adjustments. The secretary shall make household size adjustments based on the following ratios of household size as a percentage of the maximum 4-person allotment. A, for 1-person household, 30%. B, for 2-person household, 55%. C, for a 3-person household, 79%. D, for a 4-person household, 100%. E, for a 5-person household, 119%. F, for a 6-person household, 143%. For a 7-person household, 158%. For an 8-person household, 180%. For a 9-person household, 203%. For a 10-person household, 224%. For households with more than 10 persons, such as adjustment for each additional purchase for each additional person shall be 224% plus the product of 21% and the difference in the number of persons in the household and 10. Page 15 of 1018. 3. Reevaluation of market baskets. Evaluation. Not earlier than October 1st, 2028, and at not more frequently than 5-year intervals thereafter. The secretary may reevaluate the market baskets of the Thrifty Food Plan, taking into consideration current food prices, food composition data, consumption patterns, and dietary guidance. B, notice, prior to any update of the market baskets of the Thrifty Food Plan based on a reevaluation pursuant to subparagraph A, the methodology and results of any such revelation shall be published in the Federal Register with an opportunity for comment of not less than 60 days. C, cost neutrality. The secretary shall not increase the cost of the Thrifty Food Plan based on a reevaluation or update under this paragraph. 4, allowable cost adjustments. On October 1st, immediately following the effective date of this paragraph, and on each October 1st thereafter, the secretary shall A, adjust the cost of the Thrifty Food Plan to reflect changes in the Consumer Price Index for all urban consumers, published by the Bureau of Labor Statistics of the Department of Labor for the most recent 12-month period ending in June. B, make cost adjustments in the Thrifty Food Plan for urban and rural parts of Hawaii and urban and rural parts of Alaska to reflect the cost of food in urban and rural Hawaii and urban and rural Alaska, provided such cost adjustment shall not exceed the rate of increase described in the Consumer Price Index for all urban consumers, published by the Bureau of Labor Statistics of the Department of Labor for the most recent 12-month period ending in June, and make cost adjustments in the separate Thrifty Food Plans for Guam and the Virgin Islands of the United States to reflect the cost of food in those states, but not to exceed the cost of food in the 50 states and the District of Columbia, provided that such cost adjustments shall not exceed the rate of increase described in the Consumer Price Index for all urban consumers, published by the Bureau of Labor Statistics of the Department of Labor for the most recent 12-month period ending in June. Section 10002, able-bodied adults without dependents work requirements. A, Section 603 of the Food and Nutrition Act of 2008 is amended to read as follows. 3, exception, paragraph 2, shall not apply to an individual if the individual is A, under 18 or over 65 years of age, B, medically certified as physically or mentally unfit for employment, C, a parent or other member of a household with responsibility for a dependent child under 7 years of age, D, otherwise exempt under subsection D2, E, a pregnant woman, F, currently homeless, G, a veteran, H, 24 years of age or younger, and was in foster care under the responsibility of a state on the date of attaining 18 years of age or such higher age as the state has elected under Section 4758 BIII of the Social Security Act, 42 USC 6758 BIII, or I, responsible for a dependent child 7 years of age or older and is married to and resides with an individual who is in compliance with the requirements of paragraph 2. B, sunset provision. The exceptions in subparagraphs F through H shall cease to have effect on October 1st, 2030. Section 10003, able-bodied adults without dependents waivers. Section 60 of the Food and Nutrition Act of 2008, 7 U.S.C. 2015-0 is amended. 1. By amending paragraph 4A to read as follows. A. In general, on the request of a state agency and with the support of the chief executive officer of the state, the secretary may waive the applicability of paragraph 2 for not more than 12 consecutive months to any group of individuals in the state if the secretary makes a determination that the county or county equivalent is recognized by the Census Bureau in which the individuals reside has an unemployment rate of over 10%. And 2, in paragraph 6F, by striking 8% and inserting 1%. Page 19, section 10004. Availability of standard utility allowances based on receipt of energy assistance. A. Allowance to recipients of energy assistance. Section 5E6CIVI of the Food and Nutrition Act of 2008, 7 USC 2014 E6CIVI is amended by inserting with an elderly or disabled member after households. B. Third-party energy assistance payments, Section 5K4 of the Food and Nutrition Act of 2008, 7 USC 2014 K4 is amended. 1. In subparagraph A, by inserting without an elderly or disabled member after household, the first place it appears, and 2. In subparagraph B, by inserting with an elderly or disabled member after household, the first place it appears. Section 10005, restrictions on internet expenses. Section 5E6 of the Food and Nutrition Act of 2008, 7 USC 2014 E6 is amended by adding at the end of the following E. Restrictions on internet expenses. Service fees associated with internet connection, including, but not limited to, monthly subscriber fees, i.e., the base rate paid by the household each month in order to receive service, which may include high-speed internet, taxes and fees charged to the household by the provider that recur on regular bills, the cost of modem rentals and fees charged by the provider for initial installation shall not be used in computing the excess shelter expense deduction. Section 10006, matching funds requirements. A. In general, Section 4A of the Food and Nutrition Act of 2008, 7 USC 2013A is amended. 1. By striking A, subject to, and inserting the following. A. Program. 1. Establishment, subject to, and 2. By adding at the end of the following. 2. Matching funds requirements. A. In general. I. Federal share, subject to subparagraph B, the federal share of the cost of allotments described in paragraph 1 in a fiscal year shall be. I, for each of fiscal years 2026 and 2027, 100%, and page 21. 2. for fiscal year 2028 and each fiscal year thereafter, 95%. State share, subject to subparagraph B, the state share of the cost of allotments described in paragraph 1 in a fiscal year shall be I for each of the fiscal years 2026 and 2027, 0%, and 2 for fiscal year 2028 and each fiscal year thereafter, 5%. B, state quality control incentive. Beginning in fiscal year 2028, any state that has a payment error rate as defined in section 16 for the most recent complete fiscal year for which data is available of I equal to or greater than 6%, but less than 8%, shall have its federal share of the cost of allotments described in paragraph 1 for the current fiscal year equal 85% and its state share equal 15%. 2, equal to or greater than 8%, but less than 10%, shall have its federal share of the cost of allotments described in paragraph 1 for the current fiscal year equal 80% and its state share equal 20%, and 3, equal to or greater than 10%, shall have its federal share of the cost of allotments described in paragraph 1 for the current fiscal year equal 75% and its state share equal 25%. Rule of construction. The Secretary of Agriculture may not pay towards the cost of allotments described in paragraph 1 of section 4A of the Food and Nutrition Act of 2008, 7 U.S.C. 2013A, as designated by subsection A, an amount greater than the applicable federal share described in paragraph 2 of such section 4A as added by subsection A. Section 10007, Administrative Cost Sharing. Section 16A of the Food and Nutrition Act of 2008, 7 U.S.C. 2025A is amended by striking 50% and inserting 25%. Section 10008, General Work Requirement Age. Section 6D of the Food and Nutrition Act of 2008, 7 U.S.C. 2015D is amended in paragraph 1A in the matter preceding clause I by striking over the age of 15 and under the age of 60 and inserting over the age of 17 and under the age of 65. And 2, in paragraph 2A, by striking child under age 6 and inserting child under age 7, and B, by striking between 1 and 6 years of age and inserting between 1 and 7 years of age. Section 10009, National Accuracy Clearinghouse. Section 11X2 of the Food and Nutrition Act of 2008, 7 U.S.C. 2020 X2 is amended by adding at the end of the following: D, data sharing to prevent other multiple issuances. A state agency shall use each indication of multiple issuance or each indication that an individual receiving supplemental nutrition assistance program benefits in one state has applied to receive supplemental nutrition assistance program benefits in another state, to prevent multiple issuances of other federal and state assistance program benefits that a state agency administers throughout the integrated eligibility system that the state uses to administer the supplemental nutrition assistance program in the state. Page 24, Section 10010, Quality Control Zero Tolerance. Section 16C1A of the Food and Nutrition Act of 2008, 7 U.S.C. 2025 C1A is amended 1 in subclause 1 by striking and the end. 2 in subclause 2A by striking fiscal year thereafter and inserting of fiscal years 2015 through 2025, and B, by striking the period at the end and inserting semicolon, quote, semicolon, and, end quote, semicolon, and 3, by adding at the end of the following, quote, I, for each fiscal year thereafter, $0, end quote. Section 10011, National Education and Obesity Prevention Grant Program repealer. The Food and Nutrition Act of 2008, 7 U.S.C. 2011 et seq. is amended by striking Section 28, 7 U.S.C. 2036A. Section 10012, Alien SNAP eligibility. Section 6F of the Food and Nutrition Act of 2008, 7 USC 2015 F is amended to read as follows. F. No individual who is a member of a household otherwise eligible to participate in the Supplemental Nutrition Assistance Program under this section shall be eligible to participate in the Supplemental Nutrition Assistance Program as a member of that or any other household unless he or she is 1, a resident of the United States, and 2, either A citizen or national of the United States, B, an alien lawfully admitted for permanent residence as an immigrant as defined by sections 101A 15 and 101A 20 of the Immigration and Nationality Act, excluding, among others, alien visitors, tourists, diplomats, and students who enter the United States temporarily with no intention of abandoning their residence in a foreign country. C, an alien who is a citizen or national of the Republic of Cuba and who, I, is the beneficiary of an approved petition under Section 203A of the Immigration and Nationality Act. 2, meets all eligibility requirements for an immigrant visa, but for whom such a visa is not immediately available. 3, is not otherwise inadmissible under Section 212A of such act. And page 26, IV. 4, is physically present in the United States pursuant to a grant of parole in furtherance of the commitment of the United States to the minimum level of annual legal migration of Cuban nationals to the United States specified in the U.S.-Cuba Joint Communique on Migration done at New York, September 9th, 1994, and reaffirmed in the Cuba-United States Joint Statement on Normalization of Migration, building on the agreement of September 9th, 1994, done at New York, May 2nd, 1995. Or D, an individual who lawfully resides in the United States in accordance with a compact of free association referred to in Section 402B2G of the Personal Responsibility and Work Opportunity Reconciliation Act of 1996. The income less at state option, a pro rata share, and financial resources of the individual rendered ineligible to participate in the Supplemental Nutrition Assistance Program under the subsection shall be considered in determining the eligibility of the value of the allotment of the household of which such individual is a member. Page 27, Section 10013, Emergency Food Assistance, Section 203D5 of the Emergency Food Assistance Act of 1983, 7 USC 7507D5 is amended by striking 2024 and inserting 2031. Subtitle B, Investment in Rural America. Section 10101, Safety Net. A, Reference Price. Section 111119 of the Agricultural Act of 2014, 7 USC 901119 is amended to read as follows. 19, Reference Price. A, in general, subject to subparagraphs B and C, the term reference price with respect to a covered commodity for a crop year means the following. I, for wheat, $6.35 per bushel. I, for corn, $4.10 per bushel. I, for grain, sorghum, $4.40 per bushel. IV, for barley, $5.45 per bushel. V, for oats, $2.65 per bushel. VI, for long grain rice, $16.90 per hundredweight. VII, for medium grain rice, $16.90 per hundredweight. Page 28. 8, for soybeans, $10 per bushel. 9, for other oil seeds, $23.75 per hundredweight. 10, for peanuts, $630 per ton. 11, for dry peas, $13.10 per hundredweight. 12, for lentils, $23.75 per hundredweight. 13, for small chickpeas, $22.65 per hundredweight. 14, for large chickpeas, $25.65 per hundredweight. 15, for seed cotton, 42 cents per pound. B, effectiveness. Effective beginning with the 2031 crop year, the reference price is defined in subparagraph A with respect to a covered commodity shall equal the reference price in the previous crop year multiplied by 1.005. C, limitation. In no case shall a reference price for a covered commodity exceed 115% of the reference price for such covered commodity listed in subparagraph A. B, base acres. Section 1112 of the Agricultural Act of 2014, 7 U.S.C. 9012 is amended 1 in subsection D, 3A by striking 2023 and inserting 2021, and 2 by adding at the end the following E, additional base acres 1, in general, as soon as practicable, after the date of enactment of the subsection. And notwithstanding subsection A, the secretary shall provide notice to owners of eligible farms pursuant to paragraph 4 and allocate to those eligible farms a total of not more than an additional $30 million, 30 million base acres in the manner provided in this subsection. 2, content of notice. The notice under paragraph 1 shall include the following: A, information that the allocation is occurring. B, information regarding the eligibility of the farm for an allocation of base acres under paragraph 4. C, information regarding how an owner may appeal a determination of ineligibility for an allocation of base acres under paragraph 4 through an appeals process established by the secretary. Page 33, opt out. An owner of a farm that is eligible to receive an allocation of base acres may elect to not receive that allocation by notifying the secretary. For eligibility A, in general, subject to subparagraph D, effective beginning with the 2026 crop year, a farm is eligible to receive an allocation of base acres if, with respect to the farm, the amount described in subparagraph B exceeds the amount described in subparagraph C. B, 5-year average sum. The amount described in the subparagraph with respect to a farm in the sum of 1, the 5-year average of I, the acreage planted on the farm to all covered commodities for harvest, grazing, haying, silage, or other similar purposes for the 2019 through 2023 crop years, and 2, any acreage on the farm that the producers were prevented from planting during the 2019 through 2023 crop years to cover commodities because of drought, flood, or other natural disaster or other condition beyond the control of the producers, as determined by the secretary, plus 2, the lesser of 1, 15% of the total acres on the farm, and 2, the 5-year average of AA, the acreage planted on the farm to eligible non-covered commodities for harvest, grazing, haying, silage, or other similar purposes for the 2019 through 2023 crop years, and BB, any acreage on the farm that the producers were prevented from planting during the 2019 through 2023 crop years to eligible non-covered commodities because of drought, flood, or other natural disaster or other condition beyond the control of the producers as determined by the secretary. Page 32 of 1018. C, total number of base acres for covered commodities. The amount described in the subparagraph with respect to a farm is the total number of base acres for covered commodities on the farm, excluding unassigned crop base as in effect on September 30th, 2024. D, effect of no recent plantings of covered commodities. In the case of a farm for which the amount determined under clause 1 of subparagraph B is equal to 0, that farm shall be ineligible to receive an allocation of base acres under the subsection. E, acreage planted on the farm to eligible non-covered commodities defined. In this paragraph, the term acreage planted on the farm to eligible non-covered commodities means acreage planted on a farm to commodities other than covered commodities, trees, bushes, vines, grass, or pasture, including cropland that was idle or fallow, as determined by the secretary. 5, number of base acres, subject to paragraphs 4 and 7, the number of base acres allocated to an eligible farm shall, page 33, A, be equal to the difference obtained by subtracting the amount determined under subparagraph C of paragraph 4 from the amount determined under subparagraph B of that paragraph. And B, include unassigned crop base. 6, allocation of acres. A, allocation. The secretary shall allocate the number of base acres under paragraph 5 among those covered commodities planted on the farm at any time during the 2019 through 2023 crop years. B, allocation formula. The allocation of additional base acres for covered commodities shall be in proportion to the ratio of 1, the 5-year average of I, the acreage planted on the farm to each covered commodity for harvest, grazing, haying, silage, or other similar purposes within the 2019 through 2023 crop years. And 2, any acreage on the farm that the producers were prevented from planting during the 2019 through 2023 crop years to that covered commodity because of drought, flood, or other national disaster or other condition beyond the control of the producers, as determined by the secretary. To the 5-year average determined under paragraph 4 B, I, C, inclusion of all 5 years in average for the purpose of determining a 5-year acreage average under subparagraph B for the farm. The secretary shall not exclude any crop year in which a covered commodity was not planted. D, treatment of multiple planting or prevented planting for the purpose of determining under subparagraph B the acreage on a farm that producers planted or were prevented from planting during the 2019 through 2023 crop years to covered commodities. If the acreage that was planted or prevented from being planted was devoted to another covered commodity in the same crop year other than a covered commodity produced under an established practice of double cropping, the owner may elect the covered commodity to be used for that crop year in determining the 5-year average, but may not include both the initial covered commodity and the subsequent covered commodity. E, limitation. The allocation of additional base acres among covered commodities on a farm under this paragraph may not result in a total number of base acres for the farm in excess of the total number of acres on the farm. 7, reduction by the secretary. In carrying out this subsection, if the total number of eligible acres allocated to base acres across all farms in the United States under this subsection would exceed 30 million acres, the secretary shall apply an across the board pro rata reduction to the number of eligible acres to ensure the number of allocated base acres under this subsection is equal to 30 million acres. 8, payment yield. Beginning with crop year 2026, for the purpose of making price loss coverage payments under section 1116, the secretary shall establish payment yields to base acres allocated under this subsection equal to A, the payment yield established on the farm for the applicable covered commodity, and B, if no such payment yield for the applicable covered commodity exists, a payment yield I equal to the average payment yield for the covered commodity for the county in which the farm is situated, or 2, determined pursuant to section 1113C. 9, treatment of new owners in the case of a farm for which the owner on the date of enactment of this subsection was not the owner for the 2019 through 2023 crop years. The secretary shall use the planting history of the prior owner or owners of that farm for purposes of determining A, eligibility under paragraph 4, B, eligible acres under paragraph 5, and C, the allocation of acres under paragraph 6. C, producer election. Section 1115 of the Agricultural Act of 2014, 7 U.S.C. 9015 is amended. 1, in subsection A, in the matter preceding paragraph 1, by striking 2023 and inserting 2031, and 2, in subsection C, A, page 37, in the matter preceding paragraph 1, by striking 2014 crop year or the 2019 crop year is applicable and inserting 2014 crop year, 2019 crop year, or 2026 crop year as applicable. B, in paragraph 1, by striking 2014 crop year or the 2019 crop year as applicable and inserting 2014 crop year, 2019 crop year, or 2026 crop year as applicable. And C, in paragraph 2, I, in subparagraph A, by striking and at the end. 2, in subparagraph B, by striking the period at the end and inserting quote semicolon and end quote semicolon. And 3, by adding the end the following colon. C, the same coverage for each covered commodity on the farm for the 2026 through 2031 crop years, as was applicable for the 2024 crop year. D, price loss coverage. Section 1116 of the Agricultural Act of 2014, 7 USC 9016 is amended. Page 38, 1, in subsection A2, in the matter preceding subparagraph A, by striking 2023 and inserting 2031. 2, in subsection C, 1B, A, in the subparagraph heading, by striking 2023 and inserting 2031. 2, in subsection C, 1B, A, in the subparagraph heading, by striking 2023 and inserting 2031, and B, in the matter preceding clause I, by striking 2023 and inserting 2031, 3, in subsection D, by striking 2025 and inserting 2031, and 4, in subsection G, by striking 2012 through 2016, each place it appears, and inserting 2017 through 2021. E, agriculture risk coverage. Section 1117 of the Agricultural Act of 2014, 7 USC 9017 is amended. 1, in subsection A, in the matter preceding paragraph 1, by striking 2023 and inserting 2031. 2, in subsection C, A, in paragraph 1, by inserting for each of the 2014 through 2024 crop years and 90% of the benchmark revenue for each of the 2025 through 2031 crop years before the period at the end. Page 39B, by striking 2023, each place it appears, and inserting 2031, and C, in paragraph 4B, in the subparagraph heading, by striking 2023 and inserting 2031, by amending subsection D1B to read as follows: B1, for each of the crop years 2014 through 2024, 10% of the benchmark revenue for the crop year applicable under subsection C, and 2, for each of the crop years 2025 through 2031, 12.5% of the benchmark revenue for the crop year applicable under subsection C, and 4, in subsections E, G, 5, and I-5, by striking 2023 each place it appears, and inserting 2031. F, equitable treatment of certain entities. 1, in general, section 1001 of the Food Security Act of 1985, 7 USC 1308 is amended. A, in subsection A, I, by redesignating paragraph 5 as paragraph 6, and page 40, II, by inserting after paragraph 4 the following 5. Qualified pass-through entity. The term qualified pass-through entity means A, partnership within the meaning of subchapter K of chapter 1 of the Internal Revenue Code of 1986. B, an S corporation as defined in section 1361 of that code. C, a limited liability company that does not affirmatively elect to be treated as a corporation, and D, a joint venture or general partnership. B, in subsections B and C, by striking except a joint venture or general partnership each place it appears, and inserting except a qualified pass-through entity. And C, in subsection D, by striking subtitle B and all that follows through the end, the inserting Title 1 of the Agricultural Act of 2014. 2, attribution of payments. Section 1001E3BII of the Food Security Act of 1985, 7 USC 1308, E3BII is amended. Page 41 of 1018. A, in the clause heading, by striking joint ventures and general partnerships and inserting qualified pass-through entities. B, by striking a joint venture or a general partnership and inserting a qualified pass-through entity. C, by striking joint ventures and general partnerships and inserting qualified pass-through entities, and D, by striking the joint venture or general partnership and inserting the qualified pass-through entity. 3, persons actively engaged in farming. Section 1001A B2 of the Food Security Act of 1985, 7 U.S.C. 13081 B2 is amended A in subparagraphs A and B by striking in general partnership a participant in a joint venture, each place it appears, and inserting a qualified pass-through entity, and B, in subparagraph C, by striking a general partnership, joint venture, or similar entity, and inserting a qualified pass-through entity or a similar entity. Page 42. 4. Joint and several liabilities. Section 1001BD of the Food Security Act of 1985, 7 U.S.C. 13082D is amended by striking partnerships and joint ventures and inserting qualified pass-through entities. 5. Exclusion from AGI calculation. Section 1001D of the Food Security Act of 1985, 7 U.S.C. 1308-3AD is amended by striking general partnership or joint venture each place it appears. G. Payment limitations. Section 1001 of the Food Security Act of 1985, 7 U.S.C. 1308 is amended in subsection B. A, by striking B and inserting subject to subsection I, B, and B, by striking $125,000 and inserting $155,000. 2, in subsection C. A, by striking the and inserting subject to subsection I, the, and B, by striking $125,000 and inserting $155,000, and 3, by adding at the end of the following I, adjustment for the 2025 crop year and each crop year thereafter. The Secretary shall annually adjust the amounts described in subsections B and C for inflation based on the Consumer Price Index for all urban consumers, published by the Bureau of Labor Statistics of the Department of Labor. H, adjusted gross income limitation. Section 1001DB of the Food Security Act of 1985, 7 U.S.C. 1308-3AB is amended 1 in paragraph 1 by striking paragraph 3 and inserting paragraphs 3 and 4, and 2 by adding at the end of the following 4, exception for certain operations. A, definitions in this paragraph. I, accepted payment or benefit. The term accepted payment or benefit means I, a payment or benefit under subtitle E of Title I of the Agricultural Act of 2014, 7 U.S.C. 9081 at Sec. 2, a payment or benefit under Section 196 of the Federal Agriculture Improvement and Reform Act of 1996, 7 U.S.C. 7333, and 3, a payments or benefit described in paragraph 2C received on or after October 1st, 2024. Page 44. 2, farming, ranching, or silviculture activities. The term farming, ranching, or silviculture activities includes agritourism, direct-to-consumer marketing of agricultural products, the sale of agricultural equipment by a person or legal entity that owns such equipment, and other agriculture-related activities, as determined by the Secretary. B, exception. In the case of an accepted payment or benefit, the limitation established by paragraph 1 shall not apply to a person or legal entity during a crop, fiscal, or program year as appropriate, if greater than or equal to 75% of the average gross income of the person or legal entity derives from farming, ranching, or silviculture activities. I, marketing loans. 1, availability of non-recourse marketing assistance loans for loan commodities. Section 1201B1 of the Agricultural Act of 2014, 7 U.S.C. 9031B1 is amended by striking 2023 and inserting 2031. 2, loan rates for non-recourse marketing assistance loans. Section 1202 of the Agricultural Act of 2014, 7 U.S.C. 9032 is amended A in subsection B, I, in the subsection heading by striking 2023 and inserting 2025, and 2, in the matter preceding paragraph 1 by striking 2023 and inserting 2025B by redesignating subsection C and D as subsections D and E, respectively. C, by inserting after subsection B the following: C, 2026 through 2031 crop years. For purposes of each of the 2026 to 2031 crop years, the loan rate for a marketing assistance loan under section 1201 for a loan commodity shall be equal to the following: 1, in the case of wheat, $3.72 per bushel; 2, in the case of corn, $2.42 per bushel; 3, in the case of grain sorghum, $2.42 per bushel; 4, in the case of barley, $2,075 per bushel; 5, in the case of oats, $2.20 per bushel; 6, in the case of upland cotton, 55 cents per pound. Page 46. 7, in the case of extra long staple cotton, $1 per pound. 8, in the case of long grain rice, $7.70 per hundredweight. 9, in the case of medium grain rice, $7.70 per hundredweight. 10, in the case of soybeans, $6.82 per bushel. 11, in the case of other oil seeds, $11.10 per hundredweight for each of the following kinds of oil seeds: A, sunflower seed; B, rapeseed; C, canola; D, safflower; E, flaxseed; F, mustard seeds; G, cranberry; H, sesame seed; I, other oil seeds, designated by the secretary. 12, in the case of dry peas, $6.87 per hundredweight. 13, in the case of lentils, $14.30 per hundredweight. Page 47. 14, in the case of small chickpeas, $11 per hundredweight. 15, in the case of large chickpeas, $15.40 per hundredweight. 16, in the case of graded wool, $1.60 per pound. 17, in the case of non-graded wool, 55 cents per pound. 18, in the case of mohair, $5 per pound. 19, in the case of honey, $1.50 per pound. 20, in the case of peanuts, $390 per ton. D, in subsection D, as so redesignated by striking A, 11, and B, 11, and inserting A, 11, comma, B, 11, comma, and C, 11, and E, by amending subsection E, as so redesignated to read as follows: E, special rule for seed cotton and corn. 1, in general, for purpose of section 1116B2 and paragraphs 1B II and 2A II 2 of section 1117B, the loan rate shall be deemed to equal: A, for seed cotton, 30 cents per pound, and B, for corn, $3.30 per bushel. Page 48. 2, effect. Nothing in the subsection authorizes any non-recourse marketing assistance loan under this subtitle for seed cotton. 3, payment of cotton storage costs. Section 1204G of the Agricultural Act of 2014. 7 USC 9034G is amended: A, by striking effective and inserting the following: 1, crop years 2014 through 2025, effective. B, in paragraph 1, as so designated, by striking 2023 and inserting 2025, and C, by adding at the end the following: payment of cotton storage costs effective for each of the 2026 to 2031 crop years. The secretary shall make cotton storage payments for upland cotton and extra long staple cotton available in the same manner as the secretary provided storage payments for the 2006 crop of upland cotton, except that the payment rate shall be equal to the lesser of: A, the submitted tariff rate for the current marketing year; and B, in the case of storage in page 49, I, California or Arizona, a payment rate of $4.90, and 2, any other state, a payment rate of $3. 4, loan deficiency payments. A, continuation. Section 1205A2B of the Agricultural Act of 2014, 7 USC 9035A2B is amended by striking 2023 and inserting 2031. B, payment. Five, special competitive provisions for extra long staple cotton. Section 1208A of the Agricultural Act of 2014, 7 USC 9038A is amended in the matter preceding paragraph 1 by striking 2026 and inserting 2032. availability of recourse loans. Section 1209 of the Agricultural Act of 2014, 7 U.S.C. 9039 is amended in subsections A, 2, B, and C by striking 2023 each place it appears and inserting 2031. Page 50 of 1018. J, repayment of marketing loans. Section 1204 of the Agricultural Act of 2014, 7 U.S.C. 9034 is amended. 1. In subsection B, A, by redesignated paragraph 1 as subparagraph A and indenting appropriately B in the matter preceding subparagraph A as so redesignated by striking the secretary and inserting the following 1 in general, the secretary, and C by striking paragraph 2 and inserting the following B. I, in the case of long grain rice and medium grain rice, the prevailing world market price for the commodity as determined and adjusted by the secretary in accordance with this section, or 2, in the case of upland cotton, the lowest prevailing world market price for the commodity as determined and adjusted by the secretary in accordance with this section during the 30-day period following the day on which the producer repays the marketing assistance loan. Page 51, 2. Refund for upland cotton. In the case of a repayment for a marketing assistance loan for upland cotton at a rate described in paragraph 1, B, 2, the secretary shall provide to the producer a refund, if any, in an amount equal to the difference between the lowest prevailing world market price described in that paragraph and the repayment amount. 2, in subsection C, A, by striking the period at the end and inserting semicolon, and B, by striking at the loan rate and inserting the following at a rate that is the lesser of 1, the loan rate, and C, by adding at the end of the following 2, the prevailing world market price for the commodity as determined and adjusted by the secretary in accordance with this section. 3, in subsection D, A, in paragraph 1, by striking a medium grain rice and inserting medium grain rice and extra long staple cotton. 52B, by redesignated paragraphs 1 and 2 as subparagraphs A and B, respectively, and indenting appropriately. C, in the matter preceding subparagraph A as so redesignated by striking for purposes and inserting the following 1 in general for purposes, and D, by adding at the ends of the following 2, upland cotton in the case of upland cotton for any period when price quotations for middling M13 of 32-inch cotton are available. Formula under paragraph 1A shall be based on the average of the 3 lowest price growths that are quoted, and 4 in subsection E, A, in the subsection heading by inserting extra long staple cotton after upland cotton. B, in paragraph 2, I, in the paragraph heading by striking cotton and inserting upland cotton, and 2, in subparagraph B, in the matter preceding clause I, by striking 2024 and inserting 2032. Page 53. C, by redesignated paragraph 3 as paragraph 4, and D, by inserting after paragraph 2 the following extra long staple cotton, the prevailing world market price for extra long staple cotton, determined under subsection D. A shall be adjusted to United States quality and location with the adjustment to include the average costs to market the commodity, including average transportation costs as determined by the secretary. And B, may be further adjusted during the period beginning on the date of enactment of this paragraph and ending on July 31st, 2032, if the secretary determines the adjustment is necessary. I, to minimize potential loan forfeitures. 2, to minimize the accumulation of stocks of extra long staple cotton by the federal government. 3, to ensure that extra long staple cotton produced in the United States can be marketed freely and competitively. And 4, to ensure an appropriate transition between current crop and forward crop price quotations, except that the secretary may use forward crop price quotations prior to July 31st of a marketing year only if 1, there are insufficient current crop price quotations, and 2, the forward crop price quotation is the lowest such quotation available. K, economic adjustment assistance for textile mills. Section 1207C of the Agricultural Act of 2014, 7 USC 9037C is amended by striking paragraph 2 and inserting the following 2. Value of assistance. The value of the assistance provided under paragraph 1 shall be A, for the period beginning on August 1st, 2013 and ending on July 31st, 2025, 3 cents per pound, and B, beginning on August 1st, 2025, 5 cents per pound. 1. Sugar program updates. Page 55. 1. Loan rate modification. Section 156 of the Federal Agricultural Improvement and Reform Act of 1996, 7 USC 7272 is amended A in subsection A. I in paragraph 4 by striking and at the end. 2 in paragraph 5 by striking 2023 crop years and inserting 2024 crop years. And 3 by adding at the end of the following. 6, 24 cents per pound for raw cane sugar for each of the 2025 to 2031 crop years. B in subsection B. I in paragraph 1 by striking and at the end. 2 in paragraph 2 by striking 2023 crop years and inserting 2024 crop years. And 3 by adding at the end of the following. 3 a rate that is equal to 136.55% of the loan rate per pound of raw cane sugar under subsection A. 6 for each of the 2025 to 2031 crop years. And page 56C in subsection I by striking 2023 and inserting 2031. 2. Adjustments to commodity credit corporation storage rates. Section 167 of the Federal Agriculture Improvement and Reform Act of 1996, 7 USC 7287 is amended A by striking subsection A and inserting the following. A in general, the Commodity Credit Corporation shall establish rates for the storage of forfeited sugar in an amount that is not less than 1 in the case of refined sugar, 34 cents per hundredweight per month, and 2 in the case of raw cane sugar, 27 cents per hundredweight per month, and B in subsection B. I in the subsection A quad heading by striking subsequent and inserting prior, and 2 by striking and subsequent and inserting through 2024. 3 using beet sugar allotments. A. Sugar estimates. Section 359B A1 of the Agricultural Adjustment Act of 1938, 7 USC 1359B A1 is amended by striking 2023 and inserting 2031. B. Allocation to processors. Section 359CG2 of the Agricultural Adjustment Act of 1938, 7 USC 1359CCG2 is amended. I by striking in the case and inserting the following. A. In general, except as provided in subparagraph B in the case, and 2 by adding at the end of the following. Quote, B, exception, if the secretary makes an upward adjustment under paragraph 1A in adjusting allocations among beet sugar processors, the secretary shall give priority to beet sugar processors with available sugar, end quote. C, timing of reassignment. Section 359E-B2 of the Agricultural Adjustment Act of 1938, 7 USC 1359EE-B2 is amended. I, by redesignating subparagraphs A through C as clauses I through 3, respectively, and indenting appropriately. Page 58. 2, in the matter preceding clause 1 as so redesignated by striking, quote, if the secretary determines that a sugar beet processor who has been allocated a share of the beet sugar allotment will be unable to market that allocation, end quote, and inserting the following. Quote, A, in general, if the secretary determines that a sugar beet processor who has been allocated a share of the beet sugar allotment for the crop year will be unable to market that allocation, end quote, and I, by adding at the end the following, quote, timing in carrying out subparagraph A, the secretary shall dash I make an initial determination following the publication of the World Agricultural Supply and Demand Estimates in this subparagraph referred to as WASDE, approved by the World Agricultural Outlook Board by the month of January. That is applicable to the crop year for which a determination under subparagraph A is made. And page 59, I provide for initial reassignment under subparagraph AI not later than 30 days after the date of the announcement of such WASDE, end quote. 4, reallocations of tariff rate quota shortfall. Section 359K of the Agricultural Adjustment Act of 1938, 7 USC 1359 KK, is amended by adding at the end of the following C. Reallocation. 1. Initial reallocation. Subject to paragraph 3. Following the establishment of the tariff rate quotas under subsection A, for a quota year, the Secretary shall A. determine which countries do not intend to fulfill their allocation for the quota year, and B. reallocate any forecasted shortfall in the fulfillment of the tariff rate quotas as soon as practicable. 2. Subsequent reallocation. Subject to paragraph 3, not later than March 1st of the quota year, the Secretary shall reallocate any additional forecasted shortfall in the fulfillment of the tariff rate quotas for raw cane sugar established under subsection A1 for that quota year. Page 63. Cessation of effectiveness. Paragraphs 1 and 2 shall cease to be in effect if A, the agreement suspending the countervailing duty investigation on sugar from Mexico signed December 19, 2014 is terminated, and B, no countervailing duty order under subtitle A of Title 7 of the Tariff Act of 1930, 19 USC 1671, etc., is in effect with respect to sugar from Mexico. D. Refined sugar. 1. Definition of domestic sugar industry. In this subsection, the term domestic sugar industry means domestic A, sugar beet producers and processors, B, producers and processors of sugar cane, and C, refiners of raw cane sugar. 2. Study required. A, in general, not later than 180 days after the date of enactment of this subsection, the Secretary shall conduct a study on whether the establishment of additional terms and conditions with respect to refined sugar imports is necessary and appropriate. Page 61. B. Elements. In conducting the study under subparagraph A, the Secretary shall examine the following: the need for I. Defining refined sugar as having a minimum polarization of 99.8 degrees or higher. 2. Establishing a standard for color or reflectance-based units for refined sugar, such as those utilized by the International Commission of Uniform Methods of Sugar Analysis. 3. Prescribing specifications for packaging type for refined sugar. 4. Prescribing specifications for transportation modes for refined sugar. 5. Requiring affidavits or other evidence that sugar imported as refined sugar will not undergo further refining in the United States. 6. Prescribing appropriate terms and conditions to avoid unlawful sugar imports. And 7. Establishing other definitions, terms, and conditions or other requirements. 2. The potential impact of modifications described in each of the subclauses I through 7 of Clause I on the domestic sugar industry. Whether based on the needs described in Clause I and the impact described in Clause II. The establishment of additional terms and conditions is appropriate. C. Consultation. In conducting the study under subparagraph A, the Secretary shall consult with representatives of the domestic sugar industry and users of refined sugar. D. Report not later than 1 year after the date of enactment of the subsection. The Secretary shall submit to the Committee on Agriculture of the House of Representatives and the Committee on Agriculture, Nutrition, and Forestry of the Senate a report that describes the findings of the study conducted under subparagraph A. Page 63. 3. Establishment of additional terms and conditions permitted. A. In general, based on the findings in the report submitted under paragraph 2D and after providing notice to the Committee on Agriculture of the House of Representatives and the Committee on Agriculture, Nutrition, and Forestry of the Senate, the Secretary may issue regulations in accordance with subparagraph B to establish additional terms and conditions with respect to refined sugar imports that are necessary and appropriate. B. Promulgation of regulations. The Secretary may issue regulations under subparagraph A if the regulations I do not have an adverse impact on the domestic sugar industry. I are consistent with the requirements of this part, Section 156 of the Federal Agriculture Improvement and Reform Act of 1996, 7 USC 7272, and obligations under international trade agreements that have been approved by Congress. 5. Clarification of tariff rate quota adjustment. Section 359KB1 of the Agriculture Adjustment Act of 1938, 7 U.S.C. 1359 KKB1 is amended in the matter preceding subparagraph A by striking "if there is an" and inserting "for the sole purpose of responding directly to an." 6. Period of effectiveness. Section 3591A of the Agricultural Adjustment Act of 1938, 7 U.S.C. 1359 LLA is amended by striking 2023 and inserting 2031. M. Dairy policy updates. One, dairy margin coverage production history. A, definition. Section 14018 of the Agriculture Act of 2014, 7 U.S.C. 90518 is amended by striking, quote, "when the participating dairy operation first registers to participate in dairy margin coverage," end quote. B, production history of participating dairy operations. Section 1405 of the Agricultural Act of 2014, 7 U.S.C. 9055 is amended. I, by amending subsection A to read as follows. A, production history, except as provided in subsection B. The production history of a dairy operation, page 65, for dairy margin coverage is equal to the highest annual milk marketings of the participating dairy operation during any one of the 2021, 2022, or 2023 calendar years. And I, by amending subsection B to read as follows, quote, B, election by new dairy operations. In the case of a participating dairy operation that has been in operation for less than a year, the participating dairy operation shall elect one of the following methods for the secretary to determine the production history of the participating dairy operation. Quote 1, the volume of the actual milk marketings for the month the participating dairy operation has been in operation, extrapolated to a yearly amount. 2, an estimate of the actual milk marketings of the participating dairy operation based on the herd size of the participating dairy operation relative to the national rolling herd average data published by the secretary. 2, dairy margin coverage payments. Section 14068(1)(c) of the Agriculture Act of 2014, 7 U.S.C. 9056(a)(1)(c) is amended by striking 5 million and inserting 6 million each place it appears. Premiums for dairy margins, page 66A, tier I. Section 1407B of the Agriculture Act of 2014, 7 U.S.C. 9057B is amended I in the heading by striking 5 million and inserting 6 million, and 2 in paragraph 1 by striking 5 million and inserting 6 million. B, tier 2, section 1407C of the Agriculture Act of 2014, 7 U.S.C. 9057C is amended I in the heading by striking 5 million and inserting 6 million, and 2 in paragraph 1 by striking 5 million and inserting 6 million. C, premium discounts, section 1407G of the Agriculture Act of 2014, 7 U.S.C. 9057G is amended in paragraph 1 I by striking 2019 to 2023 and inserting 2026 through 2033, and page 67 2 by striking January 2019 and inserting January 2026, and 2 in paragraph 2 by striking 2023 each place it appears and inserting 2031 for duration. Section 1409 of the Agriculture Act of 2014, 7 U.S.C. 9059 is amended by striking 2025 and inserting 2031 in suspension of permanent price support authority. Section 1602 of the Agriculture Act of 2014, 7 U.S.C. 9092 is amended by striking 2023 each place it appears and inserting 2031. O, implementation. Section 1614C of the Agriculture Act of 2014, 7 U.S.C. 9097C is amended by adding the end at the end of the following. 5. Fiscal year 2025 reconciliation. The Secretary shall make available to the Farm Service Agency to carry out Section 10101 of the Act titled An Act to Provide for Reconciliation pursuant to the Title II of H. Con. Res. 14 and the amendments made by that section, $50 million to remain available until expended, of which A, not less than $5 million shall be used to carry out paragraphs 3 and 4 of subsection B. Page 68, $3 million shall be used for activities described in paragraph 3A of this subsection. C, $3 million shall be used for activities described in paragraph 3B of the subsection, and $10 million shall be used to I, carry out mandatory surveys of dairy production costs and product yield information to be reported by manufacturers required to report under Section 273 of the Agricultural Marketing Act of 1946, 7 USC 1637B for all products processed in the same facility or facilities, and 2, publish the results of such surveys biannually. P, livestock safety net updates. 1, in general, Section 1501B of the Agriculture Act of 2014, 7 USC 9081B is amended. A, by amending paragraph 2 to read as follows. 2, payment rates. A, losses due to predation, indemnity payments to an eligible producer on a farm under paragraph 1A shall be made at a rate of 100% of the market value of the affected livestock on the applicable date as determined by the Secretary. B, losses due to adverse weather or disease, indemnity payments to an eligible producer on a farm under subparagraph B or C of paragraph 1 shall be made at a rate of 75% of the market value of the affected livestock on the applicable date, as determined by the Secretary. C, determination of market value. In determining the market value described in subparagraphs A and B, the Secretary may consider the ability of eligible producers to document regional price premiums for affected livestock that exceed the national average market price for those livestock. D, applicable date defined. In this paragraph, the term applicable date means with respect to livestock as applicable I, the day before the date of death of the livestock, or page 72, the day before the date of the event that caused the harm to the livestock that resulted in a reduced sale price, and B, by adding at the end of the following. 5, additional payment for unborn livestock. A, in general, in the case of unborn livestock death losses incurred on or after January 1st, 2024, the Secretary shall make an additional payment to eligible producers on farms that have incurred such losses in excess of the normal mortality due to a condition specified in paragraph 1. B, payment rates. Additional payments under subparagraph A shall be made at a rate I determined by the Secretary, and II less than or equal to 85% of the payment rate established with respect to the lowest weight class of the livestock as determined by the Secretary acting through the administrator of the Farm Service Agency. C, payment amount. The amount of a payment to an eligible producer that has incurred unborn livestock death losses shall be equal to the payment rate determined under subparagraph B multiplied in the case of livestock described in I, subparagraph A, B, or F of subsection A 4 by 1, I, subparagraph D of such subsection by 2, I, subparagraph E of such subsection by 12, and IV, subparagraph G of such subsection by the average number of birth animals for one gestation cycle for the species of such livestock as determined by the Secretary. D, unborn livestock death losses defined. In this paragraph, the term unborn livestock death losses means losses of any livestock described in subparagraph A, B, D, E, F, or G of subsection A 4 that was gestating on the date of the death of the livestock. 2, Livestock Forage Disaster Program, Section 1501C3DII 1 of the Agriculture Act, page 72 of 2014, 7 USC 9081C3DII1 is amended. A, by striking one monthly payment and inserting two monthly payments, and B, by striking county for at least 8 consecutive and inserting the following: county for not less than. Quote, AA, 4 consecutive weeks during the normal grazing period for the county as determined by the secretary shall be eligible to receive assistance under this paragraph in an amount equal to 1 monthly payment using the monthly payment rate determined under subparagraph B, or quote BB, any of the 7 of the previous 8 consecutive, end quote. 3, emergency assistance for livestock, honeybees, and farm-raised fish. Section 1501D of the Agricultural Act of 2014, 7 USC 9081D is amended by adding at the end of the following. Page 73, 5, assistance for losses due to bird depredation. A, payments. Eligible producers on a farm of farm-raised fish, including fish grown as food for human consumption, shall be eligible to receive payments under this subsection to aid in the reduction of losses due to piscivorous birds. B, payment rate. I, in general, the payment rate for payments under subparagraph B shall be determined by the secretary, taking into account 1, costs associated with the deterrence of piscivorous birds. 2, the value of lost fish and revenue due to bird depredation. And 3, costs associated with disease loss from bird depredation. II, minimum rate. The payment rate for payments under this subparagraph B shall not be less than $600 per acre of farm-raised fish. Page 74, C, payment amounts. The amount of a payment under subparagraph B shall be the product obtained by multiplying I, the applicable payment rate under subparagraph C, and II, 85% of the total number of acres of farm-raised fish farms that the eligible producer has in production for the calendar year. 4, tree assistance program. Section 1501E of the Agricultural Act of 2014, 7 USC 9081E is amended. A, in paragraph 2B by striking 15% adjusted for normal mortality and inserting normal mortality, and B, in paragraph 3I in subparagraph AI by striking 15% mortality adjusted for normal mortality and inserting normal mortality, and 2, in subparagraph BI by striking 50 and inserting 65, and 2, by striking 15% damage or mortality adjusted for normal tree damage and mortality and inserting normal tree damage or mortality. Q, emergency assistance for honeybees and determining honeybee colony losses eligible for assistance under section 1501D of the Agriculture Act of 2014, 7 USC 9081D. The secretary shall utilize a normal mortality rate of 15%. R, beginning farmer and rancher benefit. 1, definitions. A, in general, section 502B of the Federal Crop Insurance Act, 7 USC 1502B is amended in paragraph 3 by striking 5 and inserting 10B. Conforming amendment, section 522C7 of the Federal Crop Insurance Act, 7 USC 1522C7 is amended by striking subparagraph F. 2, increase in assistance. Section 508E of the Federal Crop Insurance Act, 7 USC 1508E is amended by adding at the end of the following paragraph 9, additional support. A, in general, notwithstanding any other provision of this subsection regarding payment of a portion of premiums, a beginner farmer or rancher shall receive premium assistance, that is I, the number of percentage points specified in subparagraph B, greater than the premium assistance that would otherwise be available under paragraphs 2, except for subparagraph A of that paragraph 5, 6, and 7 for the applicable policy plan of insurance and coverage level selected by the beginning farmer or rancher, plus 2, any increase otherwise made available under this subsection B. Percentage points adjustments. The percentage points referred to in subparagraph AI are the following. I, for each of the first and second reinsurance years that a beginning farmer or rancher participates as a beginning farmer or rancher in the applicable policy or plan of insurance, 5 percentage points. I, For the third reinsurance year, that a beginning farmer or rancher participates as a beginning farmer or rancher in the applicable policy or plan of insurance, 3 percentage points. I. For the fourth reinsurance year, that a beginning farmer or rancher participates as a beginning farmer or rancher in the applicable policy or plan of insurance, 1 percentage point. S. Area-based crop insurance coverage and affordability. 1. Coverage level, Section 508C4 of the Federal Crop Insurance Act 7 U.S.C. 1508C4 is amended. A. By amending subparagraph AII to read as follows: II may be purchased at any level not to exceed 1 in the case of the individual yield or revenue coverage 85%, 2 in the case of individual yield or revenue coverage aggregated across multiple commodities 90%, and 3 in the case of area yield or revenue coverage as determined by the corporation 95%. And page 78, B in subparagraph C, I in clause II by striking 14 and inserting 10, and II in clause I1 by striking 86 and inserting 92. Premium cost share, Section 508E2HI of the Federal Crop Insurance Act 7 U.S.C. 1508E2HI is amended by striking 65 and inserting 80. T. Premium support, Section 508E2 of the Federal Crop Insurance Act 7 U.S.C. 1508E2 is amended 1 in subparagraph CI by striking 64 and inserting 69. 2 in subparagraph DI by striking 59 and inserting 64. 3 in subparagraph EI by striking 55 and inserting 64. In subparagraph FI by striking 48 and inserting 51. And 5 in subparagraph GI by striking 38 and inserting 41. U. Administrative and operating expense adjustments. Section 508K of the Federal Crop Insurance Act 7 U.S.C. 1508K is amended by adding at the end of the following 10 additional expenses. A. In general, beginning with the 2026 reinsurance year and for reinsurance year thereafter, in addition to the terms and conditions of the standard reinsurance agreement, to cover additional expenses for loss and adjustment procedures, the corporation shall pay an additional administration and operating expense subsidy to approved insurance providers for eligible contracts. B. Payment amount. In the case of an eligible contract, the payment to an approved insurance provider required under subparagraph A shall be the amount equal to 6% of the net book premium. C. Definitions. In this paragraph, I. Eligible state. The term eligible state means a state I, identified in state group 2 or state group 3, as defined in the standard reinsurance agreement for reinsurance year 2026. And page 82, in which, with respect to an insurance year, the loss ratio for eligible contracts is greater than 120% of the total net book premium written by all approved insurance providers to eligible contracts. The term eligible contract, I, means a group 1 means a crop insurance contract entered into by an approved insurance provider in an eligible state, and 2 does not include a contract for a catastrophic risk protection under subsection B, an area-based plan of insurance or similar plan of insurance as determined by the corporation, or C, a policy under which an approved insurance provider does not incur loss adjustment expenses as determined by the corporation. Page 81, 11. Specialty crops. A. Minimum reimbursement. Beginning with the 2026 reinsurance year and for each reinsurance year thereafter, the rate of reimbursement to approved insurance providers and agents for administrative and operating expenses with respect to crop insurance contracts covering agricultural commodities described in Section 101 of Title I of the Specialty Crops Competitiveness Act of 2004, 7 U.S.C. 1621, note, shall be equal to or greater than the percentage that is the greater of the following. I. 17% of the premium used to define the loss ratio. I. The percent of the premium used to define loss ratio that is otherwise applicable for the reinsurance year under the terms of the standard reinsurance agreement in effect for the reinsurance year. B. other contracts. In carrying out subparagraph A, the corporation shall not reduce, with respect to any reinsurance year, the amount or the rate of reimbursement to improved insurance providers and agents under the standard reinsurance agreement described, page 82, in clause II of such subparagraph for administrative and operating expenses with respect to contracts covering agricultural commodities that are not subject to such subparagraph. C, administration. The requirements of this paragraph and the adjustments made pursuant to this paragraph shall not be considered a renegotiation under paragraph 8A, 12A, and O, inflation adjustment. A, in general, subject to subparagraph B for the 2026 reinsurance year and each reinsurance year thereafter, the corporation shall increase the total administrative and operating expense reimbursements otherwise required under the standard reinsurance agreement in effect for the reinsurance year in order to account for inflation in a manner consistent with the increases provided with respect to the 2011 through 2015 reinsurance years under the enclosure included in Risk Management Agency Bulletin numbered MGR 10007 and dated June 30th, 2010. B, special rule for 2026 reinsurance year. The increase under subparagraph A for the 2026 reinsurance year shall not exceed the percentage change for the preceding reinsurance year included in the Consumer Price Index for all urban consumers, published by the Bureau of Labor Statistics of the Department of Labor. C, administration. An increase under subparagraph A, I, shall apply with respect to all contracts covering agricultural commodities that were subject to an increase during the period of the 2011 through 2015 reinsurance years under the enclosure referred to in that subparagraph, and I shall not be considered to be a renegotiation of the standard reinsurance agreement for purposes of paragraph 8A, the program compliance and integrity. Section 51512 of the Federal Crop Insurance Act 7 U.S.C. 151512 is amended by striking than and all that falls through this period at the end and inserting the following, quote, than, quote, A, $4 million for each of fiscal years 2009 through 2025, and page 84. B, $6 million for fiscal year 2026 and each subsequent fiscal year. W, reviews, compliance, and integrity. Section 516B2CI of the Federal Crop Insurance Act 7 U.S.C. 1516B2CI is amended by striking, quote, each fiscal year, end quote, and inserting, quote, each of fiscal years 2014 through 2025 and $10 million for fiscal year 2026 and each fiscal year thereafter, end quote. X, poultry insurance pilot program. Section 523 of the Federal Crop Insurance Act 7 U.S.C. 1523 is amended by adding at the end of the following J, Poultry Insurance Pilot Program 1 in general, notwithstanding subsection A2, the corporation shall establish a pilot program under which contract poultry growers, including growers of broilers and laying eggs, may elect to receive index-based insurance from extreme weather-related risk resulting in increased utility costs, including costs of natural gas, propane, electricity, water, and other appropriate costs as determined by the corporation associated with poultry production. Quote 2, stakeholder engagement. The corporation shall engage with poultry industry stakeholders in establishing the pilot program under paragraph 1. Page 85, 3, location. The pilot program established under paragraph 1 shall be conducted in a sufficient number of counties to provide a comprehensive evaluation of the feasibility, effectiveness, and demand among producers in the top poultry producing states, including Alabama, Arkansas, and Mississippi, as determined by the corporation. 4, approval of policy or plan. Notwithstanding section 5081, the board shall approve a policy or plan of insurance based on the pilot program under paragraph 1A in accordance with section 508H, and B, not later than 24 months after the date of enactment of this subsection. Section 10102, Conservation A, Grassroots Source Water Protection Program. Section 12400B of the Food Security Act of 1985, 16 USC 3839BB-2B is amended. 1. In paragraph 1, by striking, quote, 2023, end quote, and inserting, quote, 2031, end quote, and 2. In paragraph 3A, in subparagraph A, by striking the and at the end. Page 86, B, in subparagraph B, by striking the period at the end and inserting, quote, colon, and, end quote, colon, and. C, by adding at the end of the following, quote, $1 million beginning in fiscal year 2026 to remain available until expended, end quote. B, voluntary public access and habitats incentive program. Section 1240RF1 of the Food Security Act of 1985, 16 USC 3839BB-5F1 is amended. 1. By striking the quote and, end quote, after quote 2023, end quote, and 2. By inserting quote, comma, and $10 million for each of fiscal years 2025 through 2031, end quote, before the period at the end. See Feral Swine Eradication and Control Pilot Program. Section 2408G1 of the Agriculture Improvement Act of 2018, 7 USC 8351 notes Public Law 115-334 is amended. 1. By striking quote and, end quote, and inserting a comma, and 2. By inserting quote and $15 million for each fiscal years 2025 through 2031, end quote, before the period at the end. D. Funding. Page 87. 1. In general, Section 1241A of the Food Security Act of 1985, 16 USC 3841A is amended. A. In paragraph 2, by striking subparagraphs A through F and inserting the following. A. $625 million for fiscal year 2026. B. $650,000. B. $650 million for fiscal year 2027. C. $675 million for fiscal year 2028. D. $700 million for fiscal year 2029. E. $700 million for fiscal year 2030. And F. $700 million for fiscal year 2031. And B, in paragraph 3, I, in subparagraph A, by striking clauses I through V and inserting the following I, $2 billion, $655 million for fiscal year 2026. I, $2 billion, $855 million for fiscal year 2027. I, $3 billion, $255 million, $3,255 million for fiscal year 2028. Page 88. 4. $3,255 million for fiscal year 2029. 5. $3,255 million for fiscal year 2030. And 6. $3 billion, $255 million for fiscal year 2031. And I in subparagraph B by striking clauses I through V and inserting the following I, $1 trillion, $1,300,000,000 $1,300,000,000 for fiscal year 2026. $1,325,000,000 for fiscal year 2027. $1,350,000,000 for fiscal year 2028. $1,375,000,000 for fiscal year 2029. $1,375,000,000 for fiscal year 2030. And $1,375,000,000 for fiscal year 2031. 2. Regional Conservation Partnership Program, Section 1271D of the Food Security Act of 1985, 16 U.S.C. 3871D is amended by striking subsection A and inserting the following, page 89. A. Availability of funding of the funds of the Commodity Credit Corporation. The Secretary shall use to carry out the program to the maximum extent practicable. 1. $425 million for fiscal year 2026. 2. $450 million for fiscal year 2027. 3. $450 million for fiscal year 2028. 4. $450 million for fiscal year 2029. 5. $450 million for fiscal year 2030. And 6. $450 million for fiscal year 2031. 3. Watershed Protection and Flood Prevention. Section 15 of the Watershed Protection and Flood Prevention Act, 16 U.S.C. 1012A, is amended. A. By striking $50 million for fiscal year 2019 and inserting $150 million for fiscal year 2026. And B. By inserting to remain available until expended before the period at the end. 4. Rescission. The unobligated balances of the amounts appropriated by Section 21001A of Public Law 117-169-136 Stat 2015 are rescinded. Page 90, Section 10103, Supplemental Agricultural Trade Promotion Program. A. In general, the Secretary shall conduct a program to encourage the accessibility, development, maintenance, and expansion of commercial export markets for United States agricultural commodities. B. Funding of the funds of the Commodity Credit Corporation. The Secretary shall make available to carry out this section $285 million for fiscal year 2027 and each fiscal year thereafter. Section 10104, Research. A. Urban, indoor, and other emerging agricultural production, research, education, and extension initiative. Section 1672ED1B of the Food, Agriculture, Conservation, and Trade Act of 1997, U.S.C. 5925GD1B, is amended by striking fiscal year 2024 to remain available until expended and inserting each of fiscal years 2024 through 2031. B. Foundation for Food and Agriculture Research. Section 7601G1A of the Agricultural Act of 2014, 7 U.S.C. 5939G1A is amended, adding at the end of the following, quote, IV. Further funding of the funds of the Commodity Credit Corporation, the Secretary shall transfer to the Foundation to carry out this section to remain available until expended not later than 30 days after the date of enactment of this clause, $37 million. C. Scholarships for students at 1890 institutions. Section 1446 of the National Agricultural Research, Extension, and Teaching Policy Act of 1977, 7 U.S.C. 3222A is amended. 1. In subsection A, by striking paragraph 3, and B, by redesignating paragraph 4 as paragraph 3, and 2, in subsection B, by amending paragraph 1 to read as follows. 1. Mandatory funding of the funds of the Commodity Credit Corporation. The Secretary shall make available to carry out this section $60 million for fiscal year 2026 to remain available until expended. D. Assistive Technology Program for Farmers with Disabilities. Section 1680C of the Food, Agriculture, Conservation, and Trade Act of 1997, USC 5933C is amended. 1. In the subsection heading by striking A, authorization of appropriations and inserting funding. Page 92. 2. By redesignated paragraphs 1 and 2 as paragraphs 2 and 3 respectively, and 3 by inserting before paragraph 2 as so redesignated the following. 1. Mandatory funding of the funds of the Commodity Credit Corporation. The Secretary shall use the carry out this section $8 million to remain available until expended. And 4. In paragraph 2, and so redesignated A, in the paragraph heading by striking in general and inserting authorization of appropriations, and B, by striking, quote, subject to paragraph 2, end quote, and inserting, quote, subject to paragraph 3, end quote, C, Specialty Crop Research Initiative, Section 412K1B of the Agricultural Research, Extension and Education Reform Act of 1998, 7 U.S.C. 7632K1B is amended by striking section $80 million for fiscal year 2014 and inserting the following section. I. $80 million for each of fiscal years 2014 through 2025 and to $175 million for fiscal year 2026. Page 93. F. Research Facilities Act, Section 6 of the Research Facilities Act 7 U.S.C. 390D is amended. 1. In the section heading by striking authorization of appropriations and inserting funding, and 2. In subsection A, by striking, quote, A, in general, subject to, end quote, and inserting the following, quote, A, in general, quote, 1. Authorization of appropriations subject to, end quote, and B, by adding at the end of the following, quote, 2. Mandatory funding of the funds of the Commodity Credit Corporation. The Secretary shall make available to carry out the competitive grant program under Section 4, $125 million for each fiscal year, beginning with fiscal year 2026, end quote. Section 10105, Secure Rural Schools, Forestry. A. Extension of certain provisions of Secure Rural Schools and Community Self-Determination Act of 2000. 1. Secure payments for states and counties containing federal land. A. Secure payments. Section 101 of the Secure Rural Schools and Community Self-Determination Act of 2000. 16 U.S.C. 7111 is amended. I, in subsections A and B, by striking, quote, 2023, end quote, each place it appears, and inserting, quote, 2026, end quote, and I, by adding at the end the following, quote, E, special rule for fiscal year 2024 payments, quote, 1, state payment. If an eligible county in a state that will receive a share of the state payment for fiscal year 2024 has already received or will receive a share of the 25% payment for fiscal year 2024 distributed to the state before the date of enactment of the subsection. Quote, A, if the amount of the state payment exceeds the amount of the 25% payment, the amount of the state payment shall be reduced by the amount of the share of the eligible county of the 25% payment, or quote, B, if the amount of the state payment is less than or equal to the amount of the 25% payment, the eligible county, quote, I, may retain the amount of the share of the eligible county of the 25% payment, and quote, I, if so retained, such amount shall be treated as if it were received by the county as a state payment for purposes of this act. 2, county payment. If an eligible county that will receive a county payment for fiscal year 2024 has already received a 50% payment for fiscal year 2024A, If the amount of the county payment exceeds the amount of the 50% payment, the amount of the county payment shall be reduced by the amount of the 50% payment. Or B, if the amount of the county payment is less than or equal to the amount of the 50% payment, the eligible county I may retain the amount of the 50% payment. And I, if so retained, such amount shall be treated as if it were received as a county payment for purposes of this act. Page 96 of 1018. Three, timely payment, not later than 90 days after the date of enactment of this subsection. The Secretary of the Treasury shall make all payments under this title for fiscal year 2024. B, distribution of payments to eligible counties. Section 103D2 of the Secure Rural Schools and Community Self-Determination Act of 2001, 6 U.S.C. 7113D2 is amended by striking quote 2023 end quote and inserting quote 2026 end quote 2. Payments to states and counties. Section 102 of the Secure Rural Schools and Community Self-Determination Act of 2016 U.S.C. 7112 is amended A in subsection B, I in paragraph 1 by adding at the ends of the following. E, payments for each of fiscal years 2024 and 2025. The election otherwise required by subparagraph A shall not apply for each of fiscal years 2024 and 2025. And I in paragraph 2 by adding at the end the following. C, fiscal years 2024 and 2025. The election described in paragraph 1A applicable to a county in fiscal year 2023 shall be effective for each of fiscal years 2024 and 2025. And B in subsection D, I in paragraph 1 by adding at the end of the following. G, payments for each of fiscal years 2024 and 2025. The election made by an eligible county under subparagraph B, C, or D for fiscal year 2023 or deemed to be made by the county under paragraph 3B for that fiscal year shall be effective for each fiscal years 2024 and 2025. And I in paragraph 3 by adding at the end the following. E, payments for each of fiscal years 2024 and 2025. This paragraph does not apply for each of fiscal years 2024 and 2025. 3, extension of authority to conduct special projects on federal land. A, Committee on Composition Waiver Authority, Section 205D6C of the Secure Rural Schools and Community Self-Determination Act of 2016 U.S.C. 7125D6C is amended by striking quote 2023 end quote and inserting quote 2026 end quote. B, extension of authority, Section 208 of the Secure Rural Schools and Community Self-Determination Act of 2001, 6 U.S.C. 7128 is amended. I in subsection A by striking quote 2025 end quote and inserting quote 2028 end quote, and 2 in subsection B by striking quote 2026 end quote and inserting quote 2029 end quote. 4, extension of authority to expend county funds. Section 305 of the Secure Rural Schools and Community Self-Determination Act of 2016 U.S.C. 7144 is amended. A in subsection A by striking quote 2025 end quote and inserting quote 2028 end quote, and B in subsection B by striking quote 2026 end quote and inserting quote 2029 end quote. B, Resource Advisory Committee Pilot Program Extension, Section 205G of the Secure Rural Schools and Community Self-Determination Act of 2001, 6 U.S.C. 7125G is amended. 1, in paragraph 5 by striking quote 2023 end quote and inserting quote 2026 end quote, and 2 by striking paragraph 6, page 99 of 1118, page 99 of 1018. C, technical corrections. 1. Resource advisory committees. Section 205 of the Secure Rural Schools and Community Self-Determination Act of 2016, USC 7125, is amended A in subsection C, I in paragraph 1 by striking, quote, concerned and inserting, quote, concerned, end quote, and I in paragraph 3 by striking, quote, the date of the enactment of this act, end quote, and inserting, quote, October 3rd, 2008, end quote, and B in subsection D 4 by striking, quote, to extent, end quote, and inserting, quote, to the extent, end quote, 2. Use of project funds, section 206B2 of the Secure Rural Schools and Community Self-Determination Act of 2001, 6 USC 7126B2 is amended by striking, quote, concerned, end quote, and inserting, quote, concerned, end quote, period. D, rescissions. 1. Competitive grants for non-federal forest landowners. All the unobligated balances of the funds made available under each of the paragraphs 1 through 4 of section 23002A of subtitle D of Public Law 117-169 are rescinded. Page 100. 2. State and private forestry conservation programs. Of the unobligated balances available under section 23003A1 of subtitle D of Public Law 117-169, $100,719,676 are rescinded. Section 10106 Energy, Section 900561F of the Farm Security and Rural Investment Act of 2002, 7 USC 8105G1F is amended by striking, quote, 2024, end quote, and inserting, quote, 2031, end quote, section 10107, horticulture, A, plant pest and disease management and disease prevention, section 420F of the Plant Protection Act, 7 USC 7721 is amended, 1, in paragraph 5 by striking, quote, and, end quote, at the end, 2, by redesignated paragraph 6 by paragraph 7, 3 by inserting after paragraph 5 the following $75 million for each of the fiscal years 2018 through 2025, and 4 in paragraph 7 as so redesignated by striking $75 million for fiscal year 2018 and inserting, quote, $90 million for fiscal year 2026, end quote. B, specialty crop block grants, section 10111 of the Specialty Crops Competitiveness Act of 2004, 7 USC 1621, note, Public Law 108-465 is amended, 1, in subparagraph D by striking, quote, and, end quote, at the end, semicolon, 2 by redesignating subparagraph E as subparagraph F, 3 by inserting after subparagraph D the following E, quote, E, $85 million for each of fiscal years 2018 through 2025, and, end quote, and 4 in subparagraph F as so redesignated by striking, quote, $85 million for fiscal year 2018, end quote, and inserting $100 million for fiscal year 2026, end quote, period. C, Organic Production and Market Data Initiative, section 7407D1 of the Farm Security and Rural Investment Act of 2002, 7 USC 5925 CD1 is amended, 1, in subparagraph B by striking, quote, and, end quote, at the end, 2, in subparagraph C by striking the period at the end and inserting, quote, semicolon, and, end quote, semicolon, and 3 by adding at the end of the following quote, D, $10 million for the period of fiscal years 2026 through 2031, page 102. D, modernization and improvement of international trade technology systems and data collection funding, Section 2123C4 of the Organic Foods Protection Act of 1997, USC 6522C4, is amended in the matter proceeding subparagraph A by striking, quote, and $1 million for fiscal year 2024, end quote, and inserting, quote, $1 million for fiscal years 2024 and 2025, and $5 million for fiscal year 2026, end quote. E, National Organic Certification Cost Share Program, Section 1 of the Farm Security and Rural Investment Act of 2002, 7 USC 6523D1C, is amended by striking, quote, for each of fiscal years 2022 through 2024, end quote, and inserting, quote, for each of fiscal years 2022 through 2036, end quote. F, Multiple Crop and Pesticide Use Survey, Section 10109C1 of the Agriculture Improvement Act of 2018, Public Law 115-334132, Stat 4906, is amended to read as follows. 1, mandatory funding of the funds of the Commodity Credit Corporation, the Secretary shall use to carry out this Section A, $500,000 for fiscal year 2019 to remain available until expended. B, $100,000 for fiscal year 2024 to remain available until expended. And page 103, C, $5 million for fiscal year 2026 to remain available until expended. Section 10108, miscellaneous. A, Animal Disease Prevention and Management. Section 10409A-D1 of the Animal Health Protection Act, 7 USC 8300A-D1, is amended to read as follows. 1, mandatory funding. A, fiscal years 2023 through 2025 for the funds of the Commodity Credit Corporation. The Secretary shall make available to carry out this section $30 million for each of fiscal years 2023 through 2025, of which less than $18 million shall be made available for each of those fiscal years to carry out subsection B. B, fiscal years 2026 through 2030 of the funds of the Commodity Credit Corporation. The Secretary shall make available to carry out those section $233 million for each of the fiscal years 2026 through 2030, of which not less than $10 million shall be made available for each such fiscal year to carry out subsection A. Page 104, not less than $70 million shall be made available for each such fiscal year to carry out subsection B. And not less than $153 million shall be made available for each such fiscal year to carry out subsection C. C, subsequent fiscal years of the funds of the Commodity Credit Corporation. The Secretary shall make available to carry out this section $75 million for fiscal year 2031 and each fiscal year thereafter, of which not less than $45 million shall be made available for each of those fiscal years to carry out subsection B. B, Sheep Production and Marketing Grant Program. Section 209C of the Agricultural Marketing Act of 1946, 7 USC 1627A-C is amended. 1, by striking $2 million for fiscal year 2019, and 2, by inserting, quote, and $3 million for fiscal year 2026, end quote, after, quote, fiscal year 2024, end quote. C, miscellaneous trust funds. 1, PIMA, PIMA, Agriculture Cotton Trust Fund. Section 12314 of the Agricultural Act of 2001 for 7 USC 2101 note Public Law 113-79 is amended A in subsection B in the matter of preceding paragraph 1 by striking quote 2024 end quote and inserting quote 2031 quote end quote, and B in subsection H by striking quote 2024 end quote and inserting quote 2031 end quote. 2. Agriculture, Wool, Apparel, Manufacturers Trust Fund, Section 12315 of the Agricultural Act of 2014, 7 USC 7101, note, Public Law 113-79 is amended by striking, quote, 2024, end quote, each place is, appears, and inserting, quote, 2031, end quote. 3. Wool Research and Promotion, Section 12316A of the Agriculture Act of 2014, 7 USC 7101, note, Public Law 113-79 is amended by striking 2024, quote, end quote, and inserting, quote, 2031, end quote. 4. Emergency Citrus Disease Research and Development Trust Fund, Section 12605D of the Agriculture Improvement Act of 2018, 7 USC 73632, note, Public Law 115-334 is amended by striking, quote, 2024, end quote, and inserting, quote, 2031, end quote. Page 106 of 1018. Title 2, Committee on Armed Services. Section 20001, Enhancement of Department of Defense Resources for Improving the Quality of Life for Military Personnel. A. Appropriations. In addition to amounts otherwise available, there are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not authorized appropriated to remain available until September 30th, 2029. 1. $230,480,000 for restoration and modernization costs under the Marine Corps Barracks 2030 initiative. 2. $119 million for base operating support costs for the Marine Corps. 3. $1 billion for Army, Navy, Air Force, and Space Force sustainment, restoration, and modernizations of military unaccompanied housing. 4. $2 billion for the Defense Health Program. 5. $2.9 trillion to supplement the basic allowance for housing payable to members of the armed forces, notwithstanding Section 403 of Title 37 United States Code, page 107. C. $50 million for bonuses, special pays, and incentive pays. For members of the armed forces pursuant to Titles 10 and 37 United States Code. 7. $10 million for the Defense Activity for Non-Traditional Education Supports Online Academic Skills Course Program for members of the armed forces. 8. $100 billion for tuition assistance for members of the armed forces pursuant to Title 10 United States Code. 9. $100 million for childcare fee assistance for members of the armed forces under Part 2 of Chapter 88 of Title 10 United States Code. 10. $590 million to increase the temporary lodging expense allowance under Chapter 8 of Title 37. United States Code to 21 days. $100 million for Department of Defense impact aid payments to local educational agencies under Section 2008 of Title 10, United States Code 12. $10 million for military spouse professional licensure under Section 1784 of Title 10, United States Code 13. $6 million for armed forces retirement home facilities. And 14. $100 million for the Defense Community Infrastructure Program. Temporary increase in percentage of value of authorized investment in certain privatized military housing projects. 1. In general, during the period beginning on the date of the enactment of this section and ending on September 30th, 2029, the Secretary concerned shall apply A, paragraph 1 of subsection C of section 2875 of Title 10 United States Code by substituting 60%, quote, end quote, for, quote, 33.33%, end quote, and B, paragraph 2 of such subsection by substituting 60%, quote, end quote, for, quote, 45%, end quote. 2, Secretary concerned defined in this subsection, the terms, quote, Secretary concerned, end quote, has the meaning given such term in section 101 of Title 10 United States Code. C, temporary authority for acquisition or construction of privatized military unaccompanied housing. Section 2881A of Title 10 United States Code is amended 1 by striking the heading and inserting, quote, bold, temporary authority for acquisition or construction of privatized military unaccompanied housing, end quote. And 2, by striking, quote, Secretary of the Navy, end quote, and place it appears and inserting, quote, Secretary concerned, end quote. And 3, by striking, quote, under the pilot projects, end quote, each place it appears and inserting, quote, pursuant to this section, end quote. 4, in subsection A, by striking the heading and inserting, quote, in general, all caps, end quote. And B, by striking, quote, carry out not more than 3 pilot projects under the authority of this section or another provision of the subchapter to use this private sector, end quote, and inserting, quote, use the authority under the subchapter to enter into contracts with appropriate private sector entities, end quote. And 5, in subsection C, by striking, quote, privatized housing, and end quote, and inserting, quote, privatized housing units, end quote. And 6, by redesignated subsection F as subsection E, and 7, in subsection E as so redesignated A, by striking, quote, under the pilot programs, end quote, and inserting, quote, under this section, end quote, and page 110, B, by striking September 30th, 2009, quote, end quote, and inserting, quote, September 30th, 2029, end quote. Section 20002, enhancement of Department of Defense resources for shipbuilding. In addition to amounts otherwise available, they are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not authorized appropriated to remain available until September 30th, 2029. 1. $250 million for the expansion of accelerated training and defense manufacturing program. 2, $250 million for United States production of turbine generators for shipbuilding industrial base. 3, $450 million for United States additive manufacturing for wire production and machining capacity for shipbuilding industrial base. 4, $492 million for next generation shipbuilding techniques. 5, $85 million for United States made steel plate for shipbuilding industrial base. 6, $50 million for machining capacity for naval propellers for shipbuilding industrial base. 7, $110 million for rolled steel and fabrication facility for shipbuilding industrial base. Page 111, 8, $400 million for expansion of collaborative campus for naval shipbuilding. 9, $450 million for application of autonomy and artificial intelligence in naval shipbuilding. 10, $500 million for the adoption of advanced manufacturing techniques in the shipbuilding industrial base. 11, $500 million for additional dry dock capability. 12, $50 million for the expansion of cold spray repair technologies. 13, $450 million for additional maritime industrial workforce development programs. 14, $750 million for additional supplier development across the naval shipbuilding industrial base. 15, $250 million for additional advanced manufacturing processes across the naval shipbuilding industrial base. 16, $4,600 million for a second Virginia-class submarine in fiscal year 2026. 17, $5,400 million for 2 additional guided missile destroyer DDG ships. 18, $160 million for advanced procurement for landing ship medium. Page 112. 19, $1,803,941,000 for procurement of landing ship medium. 20, $295 million for development of a second landing craft utility shipyard and production of additional landing craft utility. 21, $100 million for the procurement of commercial logistics ships. 22, $600 million for the lease or purchase of new ships through the National Defense Delift Fund. $2,725 million for the procurement of TAO oilers. 24, $500 million for costs to complete for rescue and salvage ships. 25, $300 million for production of ship-to-shore connectors. 26, $695 million for the implementation of multi-ship amphibious warship contract. 27, $80 million for accelerated development of vertical launch system reloading at sea. 28, $250 million for expansion of Navy corrosion control programs. 29, $159 million for leasing of ships for Marine Corps operations. Page 113. 30, $1,534 million for expansion of small unmanned surface vessel production. 31, $1,800 million for expansion of medium unmanned surface vessel production. 32, $1,300 million for expansion of unmanned underwater vehicle production. 33, $188,360,000 for the development and testing of maritime robotic autonomous systems and enabling technologies. 34, $174 million for the development of a test resource management center robotic autonomous systems proving ground. 35, $250 million for the development, production, and integration of wave-powered unmanned underwater vehicles. 36, $2,100 million for San Antonio class amphibious transport dock LPD, and 37, $3,700 million for America class amphibious assault ship LHA. Section 20003, enhancement of Department of Defense resources for integrated air and missile defense. A, next generation missile defense technologies. In addition to amounts otherwise available that are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $183 million for Missile Defense Agency special programs. 2, $250 million for development and testing of directed energy capabilities by the under $500 million for national security space launch infrastructure. $2 billion for air moving target indicator military satellites. 6, $400 million for expansion of multi-service advanced capability hypersonic test bed program. 7, $5.6 billion for development of space-based and boost phase intercept capabilities. 8, $2.4 billion for the development of military non-kinetic missile defense effects. And 9, $7.2 billion for the development, procurement, and integration of military space-based sensors. Page 115. B, layered homeland defense. In addition to amounts otherwise available, they are appropriated to the Security of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $2.2 billion for acceleration of hypersonic defense systems. 2, $800 million for accelerated development and deployment of next generation intercontinental ballistic missile defense systems. 3, $408 million for Army Space strategic missile test range infrastructure restoration and modernization in the United States Indo-Pacific Command area of operations west of the international dateline. 4, $1.975 billion for improved ground-based missile defense radars. And 5, $530 million for the design and construction of Missile Defense Agency missile instrumentation range safety ship. Section 20004, enhancement of Department of Defense resources for munitions and defense supply chain resiliency. A, appropriations. In addition to amounts otherwise available, they are appropriated to the Secretary of Defense for fiscal year 2025 out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029. 1, $400 million for the development, production, and integration of Navy and Air Force long-range anti-ship missiles. 2, $380 million for production capacity expansion for Navy and Air Force long-range anti-ship missiles. 3, $490 million for the development, production, and integration of Navy and Air Force long-range air-to-surface missiles. 4, $94 million for the development, production, and integration of alternative Navy and Air Force long-range air-to-surface missiles. 5, $630 million for the development, production, and integration of long-range Navy air, defense, and anti-ship missiles. 6, $688 million for the development, production, and integration of long-range multi-service cruise missiles. 7, $250 million for production capacity expansion and supplier-based strengthening of long-range multi-service cruise missiles. 8, $70 million for the development, production, and integration of short-range Navy and Marine Corps anti-ship missiles. 9, $100 million for the development of an anti-ship seeker for short-range Army ballistic missiles. 10, $175 million for production capacity expansion for next-generation Army medium-range ballistic missiles. 11, $50 million for the mitigation of diminishing manufacturing sources for medium-range air-to-air missiles. 12, $250 million for the procurement of medium-range air-to-air missiles. 13, $225 million for the expansion of production capacity for medium-range air-to-air missiles. 14, $50 million for the development of second sources for components of short-range air-to-air missiles. 15, $325 million for production capacity improvements for air-launched anti-radiation missiles. 16, $50 million for the accelerated development of Army next-generation medium-range anti-ship ballistic missiles. Page 118. 17, $114 million for the production of Army next-generation medium-range ballistic missiles. 18, $300 million for the production of Army medium-range ballistic missiles. 19, $85 million for the accelerated development of Army long-range ballistic missiles. 20, $400 million for the production of heavyweight torpedoes. 21. $200 million for the development, procurement, and integration of commercial heavyweight torpedoes. 22. $70 million for the improvement of heavyweight torpedo maintenance activities. 23. $200 million for the production of lightweight torpedoes. 24. $500 million for the development, procurement, and integration of maritime mines. 25. $50 million for the development, procurement, and integration of new underwater explosives. 26. $55 million for the development, procurement, and integration of lightweight multi-mission torpedoes. 27. $80 million for the production of sonar buoys. 28. $150 million for the development, procurement, and integration of air-delivered long-range maritime mines. 29. $61 million for the acceleration of Navy expeditionary loitering munitions deployment. 30. $50 million for the acceleration of one-way attack unmanned aerial systems with advanced autonomy. $1 billion for the expansion of the one-way attack unmanned aerial systems industrial base. 32. $3.5 billion for grants made pursuant to the Industrial Base Fund established under Section 4817 of Title 10 United States Code. $1 billion for grants and purchase commitments made pursuant to the Industrial Base Fund established under Section 4817 of Title 10 United States Code. 34. $200 million for investments in solid rocket motor industrial base through the Industrial Base Fund established under Section 4817 of Title 10 United States Code. 35. $400 million for investments in the emerging solid rocket motor industrial base through the Industrial Base Fund established under Section 4817 of Title 10 United States Code. 36. $42 million for investments in second sources for large diameter solid rocket motors for hypersonic missiles. 37. $1 billion for the creation of next generation automated munitions production factories. 38. $170 million for the development of advanced radar depot for repair, testing, and production of radar and electronic warfare systems. 39. $25 million for the expansion of the Department of Defense Industrial Base Policy Analysis Workforce. 40. $30,300,000 for the repair of Army missiles. 41. $100 million for the production of small and medium ammunition. 42. $2.5 billion for additional activities to improve the United States production of critical minerals through the National Defense Stockpile, authorized by Subchapter 3 of Chapter 5 of Title 50 United States Code. Page 121 of 1018. $43. $10 million for the expansion of Department of Defense armaments, cooperation workforce. 44. $500 million for the expansion of Defense Exportability Features Program. 45. $350 million for production of Navy long-range air and missile defense interceptors. 46. $93 million for replacement of Navy long-range air and missile defense interceptors. 47. $100 million for development of a second solid rocket motor source for Navy air defense and anti-ship missiles. 48. $65 million for expansion of production capacity of Missile Defense Agency long-range anti-ballistic missiles. 49. $225 million for expansion of production capacity for Navy air defense and anti-ship missiles. 50. $103 million $300,000 for expansion of depot level maintenance facility for Navy long range air and missile defense interceptors. 51, $18 million for creation of domestic source for guidance section of Navy short range air defense missiles. Page 122, $50 to $65 million for integration of Army medium range air and missile defense interceptor with Navy ships. 53, $176,100,000 for production of Army long range movable missile defense radar. 54, $100 million for accelerated fielding of Army short range gun based air and missile defense system. 55, $40 million for development of low cost alternatives to air and missile defense interceptors. 56, $50 million for acceleration of Army next generation shoulder fired air defense system. 57, $91 million for production of Army next generation shoulder fire air defense system. 58, $500 million for development, production, and integration of counter unmanned aerial systems programs. 59, $350 million for development, production, and integration of non-kinetic counter unmanned aerial systems programs. 60, $250 million for development, production, and integration of land-based counter unmanned aerial systems programs. Page 123, 61, $200 million for development, production, and integration of ship-based counter unmanned aerial systems programs. And 62, $400 million for acceleration of hypersonic strike programs. B, appropriations. In addition to amounts otherwise available, there is appropriated to the Secretary of Defense out of any money in the Treasury not otherwise appropriated to remain available until September 30th, 2029, $500 million to the Department of Defense credited program account to carry out the capital assistance program, including loans, loan guarantees, and technical assistance established under Section 149E of Title 10 United States Code for critical minerals and related industries and projects, including related covered technology categories, provided that 1. Such amounts are available to subsidize gross obligations for the principal amount of direct loans and total loan principal, any part of which is to be guaranteed not to exceed $100 billion. And 2, such amounts are available to cover all costs and expenditures as provided under Section 149E 5B of Title 10 United States Code. Page 124. How did screenshot get unblocked? Oh, look, Trumpy was here. Trumpy was here in the chat. Well, if you're just tuning in, I was reading the big beautiful bill, and I got to page 124 out of 1018, and I've been live for 3 hours and 21 minutes. I felt like I was reading at a swift pace, but it seems that maybe not. So, I mean, I think I'm going to put it on hold for a while. I mean, not like, I mean, it's interesting and all, but I might have to just read like the bullet points of it or kind of skim through it. I don't think I'm ever going to read it again, ever. That was all I needed to do to decide that I'm never going to be reading that word for word ever again. And that's the truth. And I wish that I could for you guys, because I know. You're like, you don't want to read it either. And I get it. So I was kind of doing it for my audience so that they wouldn't have to do the work. But it's a little too much work. And if you would like to listen to it fully, they are doing it at hang on. Where is it? They're reading it somewhere in Congress. I can't find which site it's on though. Let me see. Where the hell was it? Anyway, it's I think in the Senate or the House. They're reading it word for word. Before the vote on it. So I guess that's somebody's goal to do that, and that's really cool. Oh, because it ain't gonna be me, that's for sure. It's pretty much 3 hours of my life that I'll never get back, and I really thought I was gonna finish that tonight. Yeah, there's a lot. And I don't think, I think everybody should read it who is voting on it for it to pass. I think that's very important. Very important. And I really don't think there's going to be a conclusion by the 4th of July like the president wants. So, yeah, I don't think that's going to happen. I can't see anybody going, I agree with every single thing in there. And you have to agree with it all to vote for it. All right? Would they have to make like changes? I would think this would take a while. A long while.
the meaning given such term in section 24H7. B, omission of correct social security number treated as mathematical or clerical. This act is further amended by striking and at the end of subparagraph 5, by striking the period at the end of subparagraph W and inserting and by inserting after subparagraph W the following new subparagraph.
I think I read that part.
An omission of a correct social security number required under section 108 F5C relating to discharges on account of death or
Never mind.
disability.
They're on a security
C,
number.
effective date. The
Security.
amendments made by this section shall
Security.
apply to discharges after December 31st, 2025.
Yeah, I didn't get that far.
Section 70120, limitation on individual deductions for certain state and local taxes, etc. A, in general, section 164B6 is amended, 1, by striking and before January 1, 2026, and 2, by striking $10,000, $5,000 in the case of a married individual filing a separate return, and inserting the applicable limitation amount, half the applicable limitation amount in the case of a married individual filing a separate return. B, applicable limitation. Section 164B is amended by adding at the end the following new paragraph. 7,
So they have been live for 7 hours.
in general. For purposes of paragraph 6,
Over
the term
7 hours.
applicable limitation amount means, 1, in the case of any taxable
We're
year
probably
beginning in
around
calendar year
pages like
2025,
300.
$40,000. 2, in the case of any taxable year beginning in calendar year 2026, $40,400. 3, in the case of any taxable year beginning after calendar year
I'll find out.
2026 and
I'm
before
gonna go look
2030,
at my,
101% of the dollar amount
through the
in
bill that I
effect
have
under
and
this
I can
subparagraph
find
for
out what
taxable
page you're
years
on.
beginning in the preceding calendar year. And 4, in the case of any taxable year beginning after calendar year 2029, $10,000. B, phase down based on modified adjusted gross income. 1, in general, except as provided in clause 3, in the case of any taxable year beginning before January 1st, 2030, the applicable limitation amount shall be reduced by 30% of the excess, if any, of the taxpayer's modified adjusted gross income over the threshold amount, half the threshold amount in the case of a married individual filing a separate return. 2, threshold amount. For purposes of this subparagraph, the term threshold amount means 1, in the case of any taxable year beginning in calendar year 2025, $500,000. 2, in the case of any taxable year beginning in calendar year 2026, $505,000. And 3, in the case of any taxable year beginning after calendar year 2026, 101% of the dollar amount in effect under this subparagraph for taxable years beginning in the preceding calendar year. 3, limitation on reduction. The reduction under clause 1 shall not result in the applicable limitation amount being less than $10,000. 4, modified adjusted gross income. For purposes of this paragraph, the term modified adjusted gross income means adjusted gross income increased by any amount excluded from gross income under section 911, 931, or 933. C, effective date. The amendments made by this section shall apply to taxable years beginning after December 31, 2024. Chapter 2, delivering on presidential priorities to provide new middle-class tax relief. Section 70201, no tax on A, deduction allowed. Part 7 of subchapter B of Chapter 1 is amended by redesignating Section 224 as Section 225 and by inserting after Section 223 the following new section. Section 224, qualified tips. A, in general, there shall be allowed as a deduction an amount equal to the qualified tips received during the taxable year that are included on statements furnished to the to Section 6041D3, 6041AE3, 6050WF2, or 6051A18, or reported by the taxpayer on Form 4137 or successor. B, limitation. 1, in general, the amount allowed as a deduction under this section for any taxable year shall not exceed $25,000. 2, limitation based on adjusted, the amount allowable as a deduction under subsection A after application of paragraph 1 shall be reduced, but not below zero, by $100 for each $1,000 by which the taxpayer's modified adjusted gross income exceeds $150,000, $300,000 in the case of a joint return. B, modified adjusted gross income. For purposes of this paragraph, the term modified adjusted gross income means the adjusted gross income of the taxpayer for the taxable year increased by any amount excluded from gross income under section 911, 931, or 933. C, tips received in course of trade or business. In the case of qualified tips received by an individual during any taxable year in the course of trade or business, other than the trade or business of performing services as an employee of such individual, such qualified tips shall be taken into account under subsection A, income for the taxpayer for such trade or business for such taxable year, including such qualified tips, exceeds the sum of the deductions other than the deduction allowed under this section, allocable to the trade or business in which such qualified tips are received by the individual for such taxable year. D, qualified tips. For purposes of this Three, cash tips. For purposes of paragraph 1, the term cash tips includes tips received from customers that are paid in cash or charged, and in the case of an employee, tips received under any tip sharing arrangement. E, social security number required. 1, in general, no deduction shall be allowed under this section unless the taxpayer includes on the return of tax for the taxable year such individual social security number. 2, social security number defined. For purposes of paragraph 1, the term social security number shall have the meaning given such term in section 24H7. F, married individuals. If the taxpayer is a married individual within the meaning of section 7703, this section shall apply only if the taxpayer and the taxpayer's spouse file a joint return for the taxable year. G, regulations. The secretary shall prescribe such regulations or other guidance as may be necessary to prevent reclassification of income as qualified tips, including regulations or other guidance to prevent abuse of the deduction allowed by this section. H, termination. No deduction shall be allowed under this section for any taxable year beginning after December 31, 2028. B, deduction allowed to non-itemizers. Section 63B is amended by striking "and" at the end of paragraph 3, by striking the period at the end of paragraph 4 and inserting and by adding at the end of the following new paragraph. 5, the deduction provided in section 224. C, omission of correct social security number treated as mathematical or clerical error. Section 6213G2, as amended by the preceding provisions of this act, is amended by striking "and" at the end of subparagraph W, by striking the period at the end of subparagraph X and inserting "and by inserting after subparagraph X the following new subparagraph. Y, an omission of a correct social security number required under section 224E relating to deduction for qualified tips. D, exclusion from qualified business income. Section 199AC4 is amended by striking "and" at the end of subparagraph B, by striking the period at the end of subparagraph C and inserting and by adding at the end of the following new subparagraph is allowable to the taxpayer under section 224A for the taxable year. E, extension of tip credit to beauty service business. 1, in general, section 45BB2 as amended is amended to read as follows. 2, application only to certain lines of business. In applying paragraph 1, there shall be taken into account only tips received from customers or clients in connection with the following services. A, the providing, delivering, or serving of food or beverages for consumption if the tipping of employees delivering or serving food or beverages by customers is customary. B, the providing of any of the following services to a customer or client if the tipping of employees providing such services is customary. 1, barbering and hair care. 2, nail care. 3, aesthetics. 4, body and spa treatments. 2, credit determined with respect to minimum wage in effect. Section 45BB1B is amended, A, by striking as in effect on January 1, 2007, and beverage establishment after without regard to section 3M of such act. F, reporting requirements. 1, returns for payments made in the course of a trade or business. A, statement furnished to secretary. Section 6041A is amended by inserting, including a separate accounting of any such amounts reasonably designated as cash tips and the occupation described in section 224D1 of the person receiving such tips after such gains, profits, and income. B, statement furnished to payee. Section 6041D is amended by striking and at the end of paragraph 1, by striking the period at the end of paragraph 2 and inserting and by inserting after paragraph 2 the following new paragraph. 3, in the case of compensation to non-employees, the portion of payments that have been reasonably designated as cash tips and the occupation described in section 224D1 of the person receiving such tips. 2, returns for payments made for services and direct sales. A, statement furnished to secretary. Section 6041A is amended by including a separate accounting of any such amounts reasonably designated as cash tips and the occupation described in section 224D1 of the person receiving such tips after amount of such payments. B, statement furnished to payee. Section 6041AE is amended by striking and at the end of paragraph 1, by striking the period at the end of paragraph 2 and inserting and by inserting after paragraph 2 the following new paragraph. 3, in the case of subsection A, the portion of payments that have been reasonably designated as cash tips and the occupation described in section 224D1 of the person receiving such tips. 3, returns relating to third-party settlement organizations. A, statement furnished to secretary. Section 6050WA is amended by striking and at the end of paragraph 1, by striking the period at the end of paragraph 2 and inserting and by adding at the end the following new paragraph. 3, in the case of a third-party settlement organization, the portion of reportable payment transactions that have been reasonably designated by payers as cash tips and the occupation described in section 224D1 of the person receiving such tips. B, statement furnished to payee. Section 6050WF2 is amended by inserting, including a separate accounting of any such amounts that have been reasonably designated by payers as cash tips and the occupation described in section 224D1 of the person receiving such tips after reportable payment transactions. 4, returns related to wages. Section 6051A is amended by striking and at the end of paragraph 16, by striking the period at the end of paragraph 17 and inserting and by inserting after paragraph 17 the following new paragraph. 18, the total amount of cash tips reported by the employee under section 6053A and the occupation described in section 224D1, such person. G, clerical amendment. The table of sections for Part 7 of Subchapter B of Chapter 1 is amended by redesignating the item relating to Section 224 as relating to Section 225 and by inserting after the item relating to Section 223 the following new item. Section 224, qualified tips. H, published list of occupations traditionally receiving tips. Not later than 90 days after the date of the enactment of this act, the Secretary of the Treasury or the Secretary's delegate shall publish a list of occupations which customarily and regularly received tips on or before December 31, 2024 for purposes of Section 224D1 of the Internal Revenue Code of 1986 as added by subsection A. 1. Withholding. The Secretary of the Treasury or the Secretary's delegate shall modify the procedures prescribed under Section 3402A of the Internal Revenue Code of 1986 for taxable years beginning after December 31, 2025 to take into account the deduction allowed under Section 224 of such code as added by this act. J, effective date. The amendments made by this section shall apply to taxable years beginning after December 31, 2024. K, transition rule. In the case of any cash tips required to be reported for periods before January 1, 2026, persons required to file returns or statements under Section 6041A, 6041D3, 6041AA, 6041AE3, 6050WA, or 6050WF2 of the Internal Revenue Code of 1986, as amended by this section, may approximate a separate accounting of amounts designated as cash tips by any reasonable method specified by the Secretary. Section 70202, no tax on overtime. A, deductions allowed. Part 7 of Subchapter B of Chapter 1, as amended by the preceding provisions of this Act, is amended by redesignating Section 225 as Section 226 and by inserting after Section 224 the following new section. Section 225, qualified compensation. A, in general, there shall be allowed as a deduction an amount equal to the qualified overtime compensation received during the taxable year and included on statements furnished to the individual pursuant to Section 6041D4 or 6051A19. B, limitation. 1, in general, the amount allowed as a deduction under this section for any taxable year shall not exceed $12,500, $25,000 in the case of a joint return. 2, limitation based on adjusted gross income. A, in general, the amount allowable as a deduction under subsection A after application of paragraph 1 shall be reduced but not below zero by $100 for each $1,000 by which the taxpayer's modified adjusted gross income exceeds $150,000, $300,000 in the case of a joint return. B, modified adjusted gross income. For purposes of this paragraph, the term modified adjusted gross income means the adjusted gross income of the taxpayer for the taxable year increased by any amount excluded from gross income under Section 911, 931, or 933. C, qualified overtime compensation. 1, in general, for purposes of this section, the term qualified overtime compensation means overtime compensation paid to an individual required under Section 7 of the Fair Labor Standards Act of 1938 that is in excess of the regular rate as used in such section at which such individual is employed. 2, exclusions. Such term shall not include any qualified tip as defined in Section 224D. D, Social Security number required. 1, in general, no deduction shall be allowed under this section unless the taxpayer includes on the return of tax for the taxable year such individual's Social Security number. 2, Social Security number defined. For purposes of paragraph 1, the term Social Security number shall have the meaning given such term in Section 24H7. E, married individuals. If the taxpayer is a married individual within the meaning of Section 7703, this section shall apply only if the taxpayer and the taxpayer's spouse file a joint return for the taxable year. F, regulations. The Secretary shall issue such regulations or other guidance as may be necessary or appropriate to carry out the purposes of this section, including regulations or other guidance to prevent abuse of the deduction allowed by this section. G, termination. No deduction shall be allowed under this section for any taxable year beginning after December 31, 2028. B, deduction allowed to non-itemizers. Section 63B, as amended by the preceding provisions of this act, is amended by striking and at the end of paragraph 4, by striking the period at the end of paragraph 5 and inserting and by adding at the end a following new paragraph. 6, the deduction provided in Section 225. C, reporting. 1, requirement to include overtime compensation on W-2. Section 6051A, as amended by the preceding provision of this act, is amended by striking "and" at the end of paragraph 17, by striking the period at the end of paragraph 18 and inserting "and by inserting after paragraph 18 the following new paragraph. 19, the total amount of qualified overtime compensation as defined in section 225C. 2, payments to persons not treated as employees under tax laws. A, statement furnished to secretary. Section 6041A, as amended by section 70201E1A, is amended by inserting "and a separate accounting of any amount of qualified overtime compensation as defined in section 225C after occupation of the person receiving such tips." B, statement furnished to payee. Section 6041D, as amended by section 70201E1B, is amended by striking "and" at the end of paragraph 2, by striking the period at the end of paragraph 3 and inserting "and by inserting after paragraph 3 the following new paragraph. 4, the portion of payments that are qualified overtime compensation as defined in section 225C. Omission of correct Social Security number treated as mathematical or clerical error. Section 6213G2, as amended by the preceding provisions of this act, is amended by striking "and" at the end of subparagraph X, by striking the period at the end of subparagraph Y and inserting "and by inserting after subparagraph Y the following new subparagraph. Z, an omission of a correct Social Security number required under section 225D relating to deduction for qualified overtime. E, clerical amendment. The table of sections for Part 7 of Subchapter B of Chapter 1, as amended by the preceding provisions of this act, is amended by redesignating the item relating to section 225 as an item relating to section 224, the following new item. Section 225, qualified overtime compensation. F, withholding. The Secretary of the Treasury or the Secretary's delegate shall modify the procedures prescribed under section 3402A of the Internal Revenue Code of 1986 for taxable years beginning after December 31st of such code as added by this act. G, effective date. The amendments made by this section shall apply to taxable years beginning after December 31, 2024. H, transition rule. In the case of qualified overtime compensation required to be reported for periods before January 1, 2026, persons required to file returns or statements under section 6051A19, 6041A, or 6041D4 of the Internal Revenue Code of 1986, as amended by this section, may approximate a separate accounting of amounts designated as qualified overtime compensation by any reasonable method specified by the Secretary. Section 70203, no tax on car loan interest. A, in general, section 163H is amended by redesignating paragraph 4 as paragraph 5 and by inserting after paragraph 3 the following new paragraph. 4, special rules for taxable years 2025 through 2028 relating to qualified passenger vehicle loan interest. A, in general, in the case of taxable years beginning after December 31, 2024 and before January 1, 2029, for purposes of this subsection, the term personal interest shall not include qualified passenger vehicle loan interest. B, qualified passenger vehicle loan interest defined. 1, in general, for purposes of this paragraph, the term qualified passenger vehicle loan interest means any interest which is paid or accrued during the taxpayer after December 31, 2024 for the purchase of and that is secured by a first lien on an applicable passenger vehicle for personal use. 2, exceptions. Such terms include any amount paid or incurred on any of the following. 1, a loan to finance fleet sales. 2, a loan incurred for the purchase of a commercial vehicle that is not used for personal purposes. 3, any lease financing. 4, a loan to finance the purchase of a vehicle with a salvage title. 5, a loan to finance the purchase of a vehicle intended to be used for scrap or parts. 3, VIN requirement. Interest shall not be treated as qualified passenger vehicle loan interest under this paragraph unless the taxpayer includes the vehicle identification number of the applicable passenger vehicle described in Clause 1 of the return of tax for the taxable year. C, limitations. 1, dollar amount. The amount of interest taken into account by a taxpayer under subparagraph B for any taxable year shall not exceed $10,000. 2, limitation based on modified adjusted gross income. 1, in general, the amount which is otherwise as a deduction under subsection A is qualified passenger vehicle loan interest determined without regard to this clause and after the application of clause 1 shall be reduced, but not below zero, by $200 for each $1,000 or portion thereof, by which the modified adjusted gross income of the taxpayer for the taxable year exceeds $100,000, $200,000 in the case of a joint return. 2, modified adjusted gross income. For purposes of this clause, the term modified adjusted gross income means the adjusted gross income of the taxpayer for the taxable year increased by any amount excluded from gross income under section 911, 911, 931, or 933. D, applicable passenger vehicle. The term applicable passenger vehicle means any vehicle, 1, the original use of which commences with the taxpayer, 2, which is manufactured primarily for use on public streets, roads, and highways, not including a vehicle operated exclusively on a rail or rails. 3, which has at least 2 wheels. 4, which is a car, minivan, sport utility vehicle, pickup truck, or motorcycle. 5, which is treated as a motorcycle for purposes of Title II of the Clean Air Act. And 6, which has a gross vehicle weight rating of less than 14,000 pounds. Such term shall not include any vehicle, the final assembly of which did not occur within the United States. E, other definitions and special rules. For purposes of this paragraph, 1, final assembly. For purposes of subparagraph D, the term final assembly means the process by which a manufacturer produces a vehicle at or through the use of a plant, factory, or other place from which the vehicle is delivered to a dealer with all component parts necessary for the mechanical operation of the vehicle included with the vehicle, whether or not the component parts are permanently installed in or on the vehicle. 2, treatment of refinancing. Indebtedness described in subparagraph B shall include indebtedness that results from refinancing any indebtedness described in such subparagraph and that is secured by a first lien on the applicable passenger vehicle with respect to which the refinanced indebtedness was incurred, but only to the extent the amount of such resulting indebtedness does not exceed the amount of such refinanced indebtedness. 3, related parties. Indebtedness described in subparagraph B shall not include any indebtedness owed to a person who is related within the meaning of section 267B or 707B1 to the taxpayer. B, deduction allowed to non-itemizers. Section 63B, as amended by the preceding provisions of this act, is amended by striking "and" at the end of paragraph 5, by striking the period at the end of paragraph 6, and inserting and by adding at the end the following new paragraph. 7, so much of the deduction allowed by section 163A as is attributable to the exception under section 163H4A. C, reporting. 1, in general, subpart B of part 3 of subchapter A of chapter 61 is amended by adding at the end the following new section.
Section 6050AA, returns relating to applicable passenger vehicle loan interest received in trade or business from individuals. A, in general, any person, 1, who is engaged in a trade or business, and 2, who, in the course of such trade or business, receives from any individual interest aggregating $600 or more for any calendar year on a specified passenger vehicle loan, shall make the return described in subsection B with respect to each individual from whom such interest was received at such time as the Secretary may provide. B, form and manner of returns. A return is described in this subsection if such return, 1, is in such form as the Secretary may prescribe, and 2, contains A, the name and address of the individual from whom the interest described in subsection A2 was received. B, the amount of such interest received for the calendar year. C, the amount of outstanding principal on the specified passenger vehicle loan as of the beginning of such calendar year. D, the date of the origination of such loan. E, the year, make, model, and vehicle identification number of the applicable passenger vehicle which secures such loan, or such other description of such vehicle as the Secretary may prescribe, and F, such other information as the Secretary may prescribe. C, statements to be furnished to individuals with respect to whom information is required. Every person required to make a return under subsection A shall furnish to each individual whose name is required to be set forth in such a return written statement shown. 1, the name, address, and phone number of the information contact of the person required to make such return, and 2, the information described in some paragraphs B, C, D, and E, subsection B2 with respect to such individual, and such information as is described in subsection B2F with respect to such individual as the secretary may provide for purposes of the subsection. The written statement required under the preceding sentence shall be furnished on or before Jan D. Definitions for purposes of this section 1 in general terms used in this section, which are also used in paragraph 4 of sections 163H, shall have the same meaning as when used in such paragraph. 2, specified passenger vehicle loan. The term specified passenger vehicle loan means the indebtedness described in section 163H4B with respect to any applicable passenger vehicle. E, regulations. The secretary shall issue such regulations or other guidance as may be necessary or appropriate to carry out the purposes of this section, including regulations or other guidance to prevent the duplicate reporting of information under this section. F, applicability. No return shall be required under this section for any period to which section 163H4 does not apply to. Penalties, section 6724D is amended. A, in paragraph 1B by striking or at the end of the clause XXVII, by striking and at the end of clause XXVII, and inserting or and by adding at the end of the following new clause. 29, section 6050A relating to returns relating to applicable passenger vehicle loan interest received in trade or business from individuals, and B, in paragraph 2 by striking or at the end of subparagraph KK, by striking the period at the end of subparagraph LL, and inserting or and by inserting after subparagraph LL the following new paragraph MM. Section 6050AAC relating to statements relating to applicable passenger vehicle loan interest received in trade or business from individuals. D, conforming amendments. 1, section 56E1B is amended by striking section 163H4 and inserting section 163H5. 2, the table of sections for subpart B of part 3 of chapter A of chapter 61 is amended by adding at the end of the following new item, section 6050